my background.
Right on my intro. Hi, everyone. I'm Ritzi Lam. I do trust and estates. And I think I know most of you here, but if you don't know, I kind of do a little bit of everything in trust and estates. I touch conservatorships, planning, a little bit of litigation. In my past life, I also did some high net worth estate planning, which is why I have a special affinity with LLC issues in estate planning. And I think that's about it.
I'm Michael Beuselinck. Good to see a lot of familiar faces. I'm not primarily a trust and estates attorney, but Ritzi probably would dispute that. She's asked me, are you really a real estate attorney or are you actually a trust? But most of my practice focuses on real estate, some litigation, transactions, property tax, which we're going to talk about some today. I think that's a major pitfall. But just to give you an intro on what I'll be discussing, and conflicts between LLC members and how to resolve them, how to watch out to try and avoid them in administration and the planning process.
So the agenda for today is I'm going to give an overview of LLCs, just in regards to formation and some of the language that you'll see in LLCs, especially as it relates to real properties. Ritzi will discuss administering LLCs if a member is incapacitated or passes away. And Mike will discuss avoiding conflicts and property taxes. So let's begin with understanding an overview of an LLC. Why do you want to create an LLC? So the key benefits of an LLC. Sorry, technical difficulties.
Connect. Is there a connect button on the back? Okay.
Here we go.
Yep. Thank you. Okay. Let's start all over. So why do we create LLCs? What are the key benefits of creating an LLC? In my mind, there's two key benefits. One is the fact an LLC is a separate legal entity, and the other component is asset protection. So what does it mean to be a separate legal entity? An LLC, in essence, if you're a member or manager of an LLC, you have certain powers. An LLC can be sued, can be enter into contracts, buy and sell properties, donate, do a whole series of things. The beauty of creating an LLC as a separate legal entity is the LLC members are not personally liable for the debts and obligations of an LLC, unless you commit fraud or if there's a personal guarantee involved. There's exceptions to that. And we'll get to understanding personal guarantees, especially when it comes to properties, as well as understanding if there's fraud involved, you don't get the protection of an LLC. And so the beauty of an LLC is that separate legal entity where the members' assets are shielded and protected and they're not liable for the debts and liabilities of the LLC. The second component is asset protection. So if you have a client that comes to you and has a commercial piece of property with high foot traffic, they also have a home worth about $3 million. And then they have, let's just say, a vacation home worth $2 million. What do you want to do? You want to protect their primary assets, which is their home, as well as their vacation home, by putting the commercial property into an LLC. By putting the commercial property into an LLC, you're shielding their personal assets from liability. So When you're dealing with a commercial property, especially high foot traffic, there's gonna be slip and falls, hands down, all the time. And so there's gonna be lawsuits, even if you have a tenant in there, the tenant is hands down going to sue the owner as well. And so if it's a severe injury and your insurance policy doesn't cover it, or for whatever reason, the policy's maxed out, you never want that person, that plaintiff, the injured person, ever going after your client's assets, such as their primary home. And so that's why you separate it in and create an LLC and separate that property and put it into an LLC, because you are shielding your client from liability if it comes to their home or other assets that they may have. And keep in mind, you can create different or several LLCs when you have a high net worth client coming in with series of, let's say, properties, right? Create different LLCs. In California, unfortunately, we don't have something called a series LLC where you create a master LLC and then a bunch of LLCs underneath it. And so here in California, you actually have to create different LLCs and stick different properties into those LLCs. So separate legal entity and asset protection are the main reasons you want to create an LLC. The third main reason is when you are dealing with LLCs versus general corporations. General corporations have a very limited structure in the sense that you have shareholders, you have directors, and you have officers of the corporation. And each, in those capacities and in those roles, it's very stringent what a shareholder can do, what a officer can do, what a director can do. But the beauty of an LLC, it's very flexible when it comes to management. So you can create an LLC where the members of that LLC manage the LLC, or you can create what we call a manager managed LLC. And we'll get to that in the next couple of slides, and I'll explain what the difference is. So the fact that an LLC offers this flexibility makes a huge difference, and it's very attractive to people in creating these LLCs. And then the last reason, key reason that you want to create an LLC is tax efficiency. LLCs are pass-throughs, and so your clients, the profits of an LLC are not taxed at a corporate level. So it makes it very far more easier, far more efficient, tax efficient for your clients to create LLCs. So what does it take to create one? It's pretty straightforward. It's pretty easy. You file a articles of organization with the Secretary of State. It's all online. You just go on the Secretary of State's website, thank you. You create a profile on the Secretary of State's website, and then you go online and you literally file an articles of incorporation in a matter of minutes. Back in the day, it would take a while, but now it's like literally, it's Secretary of State made it so easy for you to create an LLC. So it's a matter of minutes, you pay the fee. And once that article of organization is filed with the Secretary of State, you officially have an LLC in place. So what's the other document that you need? It's an operating agreement. The key issue, you may have clients that come to you and they'll ask, does an operating agreement have to be in writing? No, it doesn't. It can be oral. I do not recommend that at all. Please, even if you are dealing with one member managed LLC, you always want the operating agreement in writing, and I'll explain in a few slides why. The other document that you need is a statement of information. So once you file your articles of organization, within 90 days, I'm pretty sure it's 90 days, don't quote me on it, but you have to file the initial statement of information, and you file it with the Secretary of State. I usually do that with my clients, for my clients, because they forget. They don't remember to do that. And every 2 years, you simply update it. And inevitably, the client always forgets to update it in 2 years. And guess what happens? The Secretary of State will suspend your LLC until you update the statement of information. So I usually have a cover letter to my client once I form the LLC explaining what they have to do. And one of the things that they have to do is to file the statement of information with the Secretary of State. And the last item that you need to form an LLC is an EIN. You will need that in order to open a bank account in the name of the LLC. And so I usually have my clients just get an EIN. It's pretty straightforward. So these are the key documents that you need. They're pretty straightforward. Okay. These are the key documents that you need to create an LLC. Now let's talk about the difference between what it means to say this is a member managed LLC or manager managed LLC. To create an LLC, you need members. You simply need one member to create an LLC, but most LLCs have numerous members, several members. And so one of the conversations you need to have with your client at the onset before filing the articles of organization with the Secretary of State to ask, how many members are going to be part of this LLC? And do you want, as members, want to manage the day-to-day affairs of the LLC? And so that is a very important question to ask, because the assumption is that the LLC will be member managed unless you state manager managed. And I'll explain what it means to say manager managed. So at the onset, you need to ask your client, is it going to be member managed? And so what does that mean? In essence, the members of the LLC manage the day-to-day affairs of the LLC. Manager managed, on the other hand, is, let's say, side story, last year I dealt with an LLC that had 12 members, and one of the members was a CPA who felt that he was qualified enough to draft an operating agreement. And he drafted this operating agreement, in essence, identifying all 12 members of an LLC to be a manager of the LLC. So any decisions that the LLC had to make, all 12 members must be involved. So one of the members was a neurosurgeon. And his whole take was, I don't have time to be involved in every single decision of this LLC because I'm too busy saving lives. My response was, you should have read what you signed. You, in essence, agreed that this is a member managed LLC. So therefore, any decision that is made on behalf of the LLC has to involve all 12 members. Can you imagine? Can you imagine decisions being made by all 12 members, completely different personalities, different walks of lives, different careers, and you have to put them all in the same room and have them decide on this one piece of vacant land, in regards to one piece of vacant land and all the LLC issues that are involved in regards to that piece of vacant land. Let me tell you, it's very difficult. So my proposal was, let's amend and restate the entire operating agreement, appoint 3 members of the LLC to become managers. And so they are, in essence, the managers of the LLC. They make decisions as to the LLC, the day-to-day affairs of the LLC. So they don't need to call all the other members and go, hey, we have to have a meeting. We got to make a decision. No, they have the power to make that decision. When you have a manager managed LLC, it's very, very important to ask clients, do you want to limit some of their powers? So going back to the story about the 12-member LLC. So when we had that meeting, the members said, well, we don't want these managers making a series of decisions without our involvement. So I said, okay, so we can draft limiting language in the operating agreement. And one of the limiting language was, managers, if you cut a check, you have the authority to cut a check up to $5,000. Anything beyond that, you have to notify all the other members. If you're making capital improvements on one of the commercial pieces of property, you have to notify all of the other members. So you can put that kind of language in an operating agreement when you have a manager managed LLC to limit the manager's powers based on what the members want to do. But keep in mind, managers, hands down, cannot sell, lease, exchange, or dispose of the LLC's properties without the consent of the members. So if you have a manager-managed LLC and they are trying to sell a piece of property, the lender or the title company will ask for what we call a unanimous consent of all the members saying, hey, you are the 12 members of this LLC and you are okay with this manager to sell this piece of property that is an asset of the LLC. So it goes back to the original or the question that I had or question that I proposed, which is, should operating agreements be in writing? Yes, they should. This is a prime example of why it should be in writing, because if you have 3 managers and you have series of members that do not want to give these managers complete sole power, you need limiting language. And how do you get to that? Is by actually drafting an operating agreement. There's also several reasons why you want an operating agreement. The other reasons is if you want to open up a bank account in the name of the LLC, which you should, just to meet corporate formalities and to maintain that shield that you want for your clients so their assets are protected, banks will ask for a written, most scenarios, banks will ask for a written operating agreement. So they want something in writing saying, these are the members of the LLC and they have powers to do X, Y, and Z. If the LLC has a piece of property in there and they want to refi, or if, you know, there's no loans against it and they want to get a loan against that piece of property, hands down, a lender will ask for a copy of the operating agreement because they want to review that operating agreement to make sure the member or the manager, there's necessary language about not only selling a piece of property, but getting loans and have the authority to execute the loans. So it becomes really, really important to have operating agreements in writing. So you file the necessary documents to create the LLC. You then prepare the operating agreement that says, hey, it's member managed, manager managed, however, whatever your client wants. Then you have to make the members have to make a capital contribution to the LLC. The LLC can't just sit there as a shell. It has to be funded. Either, and the Corporations Code section identifies the ways that you can fund an LLC. So you can fund it with a property, with money, promissory notes, which I have a side story on that, contracts for services to be performed, and any benefits to the LLC qualifies as a valid contribution. So your client has, or the member or manager of, the member of the LLC has to contribute something to that LLC for it to exist and continue to exist. It can't just sit empty. You can't just create one and have nothing in it. So this is where capital contribution becomes really fascinating, at least in my book. So let's say, a member contributes a piece of property, a real property, to the LLC. That piece of property cannot be held in the name of the member as an individual. You have to record a grant deed transferring that interest in the property into an LLC. Why? Because you want to maintain that protection that that LLC has. Otherwise, if you don't transfer that property, it means nothing. Really, it means nothing. And I'll talk about alter ego doctrine and piercing the corporate veil. But one of the key components when you're dealing with real property is to make sure that the title to the property is transferred into the LLC's name. And so the other component that you have to think about is thinly capitalized LLCs. I once reviewed an operating agreement that the capital contribution was a promissory note, okay? And as I'm reviewing this operating agreement, there's some confusing language about capital contribution of this promissory note. So I asked the client, can you email me a copy of this promissory note? So I look at the promissory note, and the client is not the holder of the promissory note, meaning he's not the person who benefits from the promissory note. He's the borrower. So he literally funded this LLC with debt, no assets. And so I'm scratching my head going, am I missing something? What's going on here? So I called the client. I'm like, hey, what's going on? Why did you do this? And I know none of you would ever do this. He's like, I don't know. My estate planner told me to do this. So I just put the debt in there. And I'm like, yeah, well, you can't do that. There has to be some sort of an asset, not simply liability in an LLC. So here's why, because if it's a thinly capitalized LLC, or it's simply a shell to protect your debt, or people coming after you because of this debt, then hands down, they can pierce the what we call they can invoke the alter ego doctrine and pierce the corporate veil and go after your personal assets because your LLC is simply a shell. So that's really, really important to understand. The other component that I want to raise, when you are transferring a piece of property into an LLC, you must ask your client, this is really important, you must ask your client if there is a loan on that property, and here's why. You need to review that promissory note and deed of trust, because there will be this language, most likely this language, in that promissory note or deed of trust. So the language says, if all or any part of the property or any interest in the property is sold or transferred without the lender's consent, the lender can call the entirety of that note in 30 days or more, okay? So if there's a lien against the property for $1 million, you transfer that property from the individual's name into an LLC without the lender's written consent. And if you have a broad language like this and the lender finds out, they can arguably call the entirety of the note. So it's very, very important before you transfer pieces of properties into an LLC to make sure if there is a lien against the property, you review the promissory note and the deed of trust and advise the client. I have some clients who say, I don't care, let them call the note. I have enough equity, I'll go refi. Okay, we transfer it and we wait and see if the lender calls the note. If you're paying your mortgage on time, most times the lenders won't pick it up. But there's a risk. The probability might be low, but there's always a possibility the lender will pick up on it and call out the note. So it is very important that you advise your client in regards to a written consent of the lender and an acceleration clause, because that is the risk that they're taking. The other component, I have also another side story.
It's okay.
Okay.
Keep going.
I feel like most days I'm correcting other people's mistakes when it comes to operating agreements. When you are transferring a piece of property from an individual, let's say a series of individuals hold a piece of property, let's just say a commercial piece of property. So there's 5 people on title, right, with different percentages of ownership. You want to make sure that percentage matches up as you're transferring it into an LLC. And here's why. I had a case a few months ago where the client calls me up and he says, this property's in the LLC, but the title company's telling me the LLC only owns 99.8%. That is very unusual. So I'm scratching my head going, what? So I pull up all the deeds. And I'm looking at all these deeds and I'm trying to piecemeal everything. So it happens that the settlor of the trust, the mom, goes to an estate planning attorney. The estate planning attorney then creates, this trust. This trust owns a series of assets, and one of the assets is a commercial piece of property. She then LLC, then goes and sees a tax attorney. And tax issues are way beyond my pay grade. I don't deal with taxes for a reason, and this is why. Tax attorney then takes a portion of the interest out of the LLC, transfers it back to the trustee of the trust, and then gives a series of interest to the beneficiaries of the trust as individuals. He then takes all of those interests and then calculates something and realizes, hey, the trustee has a series of interests, so then transfers more of the trustee's interest in the LLC to the three beneficiaries. So it ends up, the trust has 50.3, I think, interest in the LLC. I'm sorry, in the property, and the other beneficiaries have 16.6%. Then he takes all of their interests and puts it back, but he puts percentages in there, right? So if you add up the 16.6, it should have been 16.66. So he messed up. So he literally transferred 99.8% into the LLC. So when the client was trying to get a loan on a piece of property and title's going, well, you don't have complete title to this property. The LLC doesn't have complete title to this property. 0.2% is owned by these three beneficiaries and the trust. So we had to do, it was a very expensive mistake for the client. We had to do this correction, this complicated correction deed, in essence, correcting this mistake. So when you are transferring property into an LLC, please make sure the percentages are accurate, or if you're just simply doing transfers, weird transfers for whatever reason. And I'm sure there was a reason why this tax attorney was doing this. I have no idea what that reason is, but I'm sure there was a legitimate reason. But again, just make sure the transfer of interest in property matches up to the percentage. So I just want to raise personal guarantees for when it comes to real property transfers into an LLC. A lender will always ask for a personal guarantee because of the fact that they want to make sure that their security is secured, right? So keep in mind, even though you create an LLC and there is series of protections, that protection doesn't apply to loans because lenders will ask for personal guarantee. And landlords, hands down, will ask for personal guarantee. They don't want tenants as entities. They want to make sure they get paid their rent as well as any operating expenses. So they will ask, if a tenant is an LLC, they will ask each member to guarantee the lease, the obligations under the lease. So sometimes what I do in that scenario, if it's a multi-member LLC and I know what their intentions are, I will put in language because people don't like personal guarantees. You're putting all your asset on the hook, right? By doing a personal guarantee. And so some members will say, no, we don't want to do a personal guarantee. And so it ends up being a conflict where the LLC needs to do this act, but the members are not agreeing to do this act because of the personal guarantee issue. And so I will have language in a personal guarantee and that says if a personal guarantee is required, the members agree to do a personal guarantee. So there's no conflict in the future. But I threw this personal guarantee issue in there just so that you're aware that lenders and landlords, despite creating an LLC, despite trying to shield your client, will work around it and ask for a personal guarantee.
Ask a question about that or questions at the end?
At the end, please.
Okay.
Thank you. I just want to point out certain critical clauses in LLC operating agreements, which my co-presenters will go into detail. But I just want to point out, when you're reviewing an operating agreement, please pay attention to the voting requirements. Please make sure you understand the difference if there's language in there about majority, supermajority, or unanimous. There are certain decisions that have to be unanimous. A member's consent has to be unanimous on certain issues. And certain issues, it simply requires majority. And sometimes operating agreements are written in a way where it requires supermajority, which is 66 2/3% of the percentage interest. And figuring that out can be a little bit complicated. So, but in essence, pay attention to the language of the operating agreement. If a client is coming in there and saying, you're helping them with administrating the trust, administrating the LLC, please pay attention to the language of, is it majority, supermajority, or unanimous for certain acts. But do remember, and I have read operating agreements that don't, for whatever reason, say that any amendments to the articles of organization or the operating requires only the vote of a small number of members. That is not the case. That's against the law. Are any amendments to the articles of organization or the operating agreement requires a unanimous vote of all members. So be wary of that. If you want to change for whatever reason the operating agreement, or you want to amend the articles of organization, you need a unanimous vote of all members. And then the other key language in operating agreements are buyouts. If you're drafting operating agreements, hands down, have buyout language. You don't want these people end up in litigation. You just don't. So you want to buy out. If someone wants to, leave the LLC because of the dynamic of the members has gone to crap, or they can't agree with certain big issues, you want the other party to be able to sell their interests. Hopefully, there's assets enough for other people to buy. But you want buyout language, and Ritzi and Mike are going to talk about buyout languages and succession language. Succession language becomes really important, especially when you're dealing with a single member managed LLC. You want, if that person gets hit by a bus, you want someone to quickly step into their shoes to whatever needs to be done with the LLC, especially dissolving the LLC. And Ritzi's going to talk more about that. One of the things that I personally really am an advocate of in putting in operating agreements is mediation provisions. I don't know how many of you are litigators, but as you know, litigation is expensive. It's time consuming. It's emotionally taxing for your clients, right? And so mediation is a good way to resolve the differences between members or members and managers. And so I usually ask the client, can I put a mediation provision? And here's why. They never say no. Arbitration provision, on the other hand, it's hit or miss depending on what the client wants. You could put an arbitration provision in an operating agreement. This is a way to avoid forcing the parties to dissolve the LLC. And the only way, if you can't agree to dissolve an LLC, the only course of action you have is to file a lawsuit for dissolution of an LLC, which, as you know, is expensive. Yeah, one more. Just because a lot of you deal with trust and estates, I felt like I had to put fiduciary duties in there because you guys are familiar with that. So remember, members and managers, there's fiduciary obligations in LLCs. So members and managers do have duties of loyalty, duties of care. And the law is very stringent on that. You cannot eliminate those duties by saying something in an operating agreement. And so you can limit them to a certain extent, but you cannot eliminate them. So I felt the need to put in this slide just because of fiduciary duties. Oh, awesome. So piercing the corporate veil and alter ego doctrine. I think this is really, really important. And it goes, you'd never want to end up here in where you're explaining to the client, well, they can, because of your actions, because of this lawsuit, they can, they've invoked the alter ego doctrine and they can pierce the corporate veil. You never want the client in that situation. So what do? At the onset, when you create your LLC, you guide them along. And as I said earlier, I always have a cover letter to them saying, hey, don't commingle. If you commingle, you lose that shield that you have created by forming this LLC, and they can go after your other assets. So don't commingle your asset. What does this mean? Do not use the LLC's bank account as your personal ATM machine. Do not commingle your personal assets with the assets of the LLC. It has to be separated. Everything has to be separated. Your bank account should be in the LLC's name. Your credit card should be in the LLC's name. If you're dealing with 2 or more LLCs, don't commingle the assets of those LLCs because you lose that protection completely for all your LLCs. And that's insane in my mind if you do that. Again, undercapitalization, right? That goes to the promissory note story that I shared with you guys. Make sure your clients are capitalizing properly with viable assets, the LLC. That becomes really, really important. And then meeting corporate formalities. LLC's corporate formalities are not as stringent as a general corporation, but you still have to meet them. And what does that mean? It's, you know, one way is to have a written operating agreement and following the structure of the operating agreement when you're making decisions. If a major decision is made as to buying, selling a piece of property, getting a loan, whatever it may be, you have a written consent acknowledging those actions. And so that in those methods, you are meeting corporate formalities and you're maintaining corporate formalities, so you're protecting your assets. And the last thing is not to commit fraud. Simple as that, right? So if a member commits fraud, the liability protection typically offered by the LLC structure can be pierced. I also have a side story on this. In my litigation days, I was dealing with non-disclosure cases. So an LLC is a flipper, sells a completely gutted, remodeled piece of property to my client, who's a first-time buyer. And in their disclosure says that everything that has been done on this piece of property is with permits. Actually said that. We find out, my poor client finds out later that nothing was permitted. There was no structural engineer involved, and they took out load-bearing walls that affected the structure, the integrity of the whole building. Nothing was permitted, no structural engineers were involved, no licensed contractors were involved. It was insane. So what do? I file a lawsuit and I argue alter ego doctrine and a series of things. The other side's counsel calls me up and says, good luck collecting. We're an LLC, there's no assets. And in a very professional manner, I explained to him, your client committed fraud. Guess what? I'm coming after all your assets. So, you know, fraud does not protect you. Do not commit fraud. You know, and I mean, I'm obviously stating the obvious here and making a little bit joke of it, but it does not, you lose that protection. It doesn't matter if you have no assets in the LLC and you're telling the other side, I have no assets, good luck collecting. No, we can come after your personal assets because you've committed fraud. And the last slide is dissolution. So if the members are in agreement and they get along, and for whatever reason they decide to dissolve the LLC, they can do it by majority vote, and it's very straightforward. You just file something with the Secretary of State and you dissolve the corporation. You never want to get into the judicial dissolution component of it. Is as I explained, that's where the mediation provision in your operating agreement helps. I sometimes get calls about partition actions, and the first question I ask is, how is title held? If it's held in an LLC, you can't partition. You have to dissolve the LLC, and Mike's going to talk more about that. You have to dissolve the LLC and then seek for partition. Okay, so you don't ever want your clients ending up in this asking for judicial dissolution. You know, at that point, shit's hit, pardon my language, but you know, it's bad. It's really, really bad. So you never want that in that scenario. And so it's really important to have the necessary language in the operating agreement, or look for the necessary language in the operating agreement to make sure, is there a mediation provision? Is there an arbitration provision? And also buyout. Is there a buyout language in there that allows the party who wants to no longer be a member of that LLC to be able to be bought out by the other members of the LLC? So these are very, very important, important components that either help with the dissolution component or prevent judicial dissolution. That said, I'm going to switch over to Ritzi, who's going to talk about incapacity and death.
Favorite topics of estate planners, right? Incapacity and death. So I really quickly want to touch on the one thing that Vahishta talked about. So how many of you use LLCs in your estate planning? How many of you have administered an estate with LLC issues? Okay, so more of you have administered them. Okay. I mean, you know, you take them as they come, right? You don't get to pick and choose necessarily what assets are there. So with the thing that Vahishta was talking about, the statement of information that needs to be filed with the Secretary of State every 2 years, there are corporate services that handle these. So I always recommend that clients, if you don't want to have to keep track of everything that you need to do for your LLC, just hire one of these services. They're about, I think, maybe $100 a year. It's very inexpensive, and obviously you can write it off as part of your operating costs. So I think that's money well spent. Okay, can you give me that? Thank you. I hope this works. Okay, so I'm going to start off with talking about, management issues. If you have a managing member who's incapacitated, who takes over, who votes on behalf of the incapacitated member? Well, the simple answer is, if you have a member managed LLC or you have multiple managers, then simply, obviously, the manager who is incapacitated doesn't participate anymore. If you're talking about a single manager or single member LLC, that's a different story, and we'll address that later. But then the question is, if you have a member who has a vote and they're incapacitated, what happens? Who steps in on that person's shoes? Then you have to also define, what does incapacity mean? Oftentimes, I find that people that are in business, maybe even our own clients, they're not necessarily lining up to say, yes, I lack capacity. They're the ones that want to keep going. They say there's nothing wrong with me. I think the sky is pink, but the sky is pink, everything is totally normal. The interesting thing about a lot of operating agreements is that they don't really define incapacity. I had to really search for some kind of an operating agreement that defined incapacity, and I found one in a corporate agreement, which is why the sample language here talks about a corporation or shareholder. But in this case, you can basically substitute shareholder for a member of an LLC. And as you read it, the people here who draft trust, you'll see that the language regarding incapacity is very similar to how we as trust and estate practitioners define incapacity in our trust documents. Oh, good, okay. But if the operating agreement doesn't define incapacity, then we can refer to several outside documents. So if The member of the LLC is a member in their capacity as a trustee of their own trust. You can look to the trust document. Hopefully the trust document, if properly drafted, actually has a definition for incapacity. If the member is the incapacitated member is a member in their individual capacity, see if there's a durable power of attorney that hopefully includes the power to carry on businesses or business transactions for the incapacitated member. And if there's no trust and no power of attorney, then you're stuck going to court and getting a conservatorship. So with a conservatorship, as you may know, a conservatorship can be very general, but there's also a probate code section 2590 that specifies certain powers, certain additional powers that are kind of special that are not your day-to-day conservatorship powers, such as making decisions for someone's medical or financial. There is a specific code section 2591 that refer to 2590A, the power to operate for a period longer than 45 days at the risk of the estate, a business, farm, or enterprise. So the key word here is enterprise. It's an LLC or an LP, whatever the business is, constituting an asset of the estate. So if your incapacitated individual is a member, manager, you can always use this, use a conservatorship in order to have the conservator step into the shoes of the incapacitated manager or member. Yeah, so it's not enough just to get the conservatorship, you actually need to request the specific power. Okay. All right, so our member is not just incapacitated, but is now deceased. So there's a few things to do. And this is going to be true whether the person died intestate or testate, is you're going to need to sorry, my outline is a little off. Okay. Let's talk about the procedural issues. If your decedent died intestate, if your decedent died intestate, then naturally you're going to need to go to a probate. The LLC interest is one of the assets that needs to go through probate. If you have a decedent that died intestate but was married, and assuming that this is a single member LLC, so your decedent, while married, was the only member in a single member LLC, you can use a spousal property petition to have it confirmed to the surviving spouse. And then it would be up to the surviving spouse to either continue on the operations or to wind down and dissolve the LLC. Okay. And then the other issue is, okay, let's say they did not die intestate and they had a trust, but this LLC was not necessarily listed in their schedule of assets or a general assignment exists. Then it's kind of like any other asset, like for example, a house that someone didn't put back into their trust after they took it out for refinancing. You would simply do it a 50 petition to basically have a court confirm the LLC interest or the membership to the person's trust. I recently had a case. It was a long-time trust. The trust was maybe 30 years old, husband and wife. The wife back in the 70s had started a corporation. It was actually a C Corp. So it was way back in the day when, S Corps and other smaller entities weren't available. So it was a C Corp. And she had in her name for over 50 years. She was incapacitated for the last 10 years of her life, but no changes were ever made. So all the tax returns were still filed under her name as the owner of the corporation. Well, thankfully, there was general assignment language in the trust that we were able to use to do a ex parte Hegstead because everyone agreed to it. So in some ways, LLCs and corporations seem kind of daunting, but when treating it as an asset to be transferred into a trust, it's just like any other asset. You just use an 850 petition. And if everyone agrees to it in contra costa, you could have an ex parte. So, All right, then we talk, and then the transfer and assignment or purchase of the membership interest. Oh, wait, sorry. I'm looking at two different notes right now, so. Oh.
Yeah.
Sorry, the transfer and assignment of purchase. So always refer to the operating agreement, like Vahishta said. Hopefully the operating agreement is clear about what happens when someone passes away, especially if they don't have their own estate plan that says what happens to their interest in the event that they pass away. And even worse is if they do have an estate plan and it says that their interests are supposed to go to people that are prohibited transferees. So a lot of times LLCs are closely held companies. They are normally created by people that, they want to go into business together. Hopefully they're like-minded individuals. But as you start having the members passing away and they start, and these membership interests get diluted by way of transfer because of death, inheritance, then you suddenly potentially have other people that come into the LLC that were not supposed to be, that they never anticipated to be members. Then you have the issue of, well, do these people have voting rights? Do they have a say in how to run the company? Do they have a say in when distributions come out? All that stuff. So it becomes kind of messy, and hopefully your operating agreement is clear as to maybe the kinds of people that this can go to. This comes up a lot more in limited partnership agreements, LPs. So a little segue into what an LP is. An LP is very similar to an LLC. And I think LPs were a lot more popular back in like the 80s and the 90s before LLCs became more of a thing, for lack of a better word. And I think in the context of estate planning, LPs are really popular for families where the parents want to maintain control of the rental property, but they also want to take advantage of the ability to gift limited partnership shares to their children. So the parents remain the general partner, the GP. They have the liability, but they're able to start gifting away their net worth by giving parts of their partnership interest to these children. With those particular entities, the LPs, there might be more restrictive language where, for example, I have one LP right now where there are prohibited transferees, which are non-blood relatives. So for example, if you have one of the children that are limited partners that pass away, they have no child, but they left a widow. The widow is not a permitted transferee. She cannot actually become a limited partner in that partnership. So that becomes a problem, and that's when you need to talk about a buyout. And again, hopefully your operating agreement has good buyout language. If not, it could be litigated. There could be a whole host of problems that come with it. And if there is a situation of a buyout, whoever is the personal representative of the decedent's estate or the trustee, they end up being the selling member. So let's see. Okay. So one of the things that you have to do after a person has passed away is actually to, like all their assets, right? You have to do kind of an inventory and appraisal. You have to figure out what the decedent's assets were and how much they were worth. With an LLC interest, that gets a little bit more complicated because oftentimes people think, well, the LLC has a piece of property that's worth like $1 million. So 25% of it should be $250,000. Well, that's not how it works in an LLC because, or appraising an LLC interest, because the interest comes with its own strings attached, right? For example, with the 25% interest owner, if you have somebody else who owns 50% or 75%, then clearly the 25% interest owner doesn't have a majority say, doesn't really have a say at all. And also if there are restrictions about being able to transfer the interest or sell the interest, then you have an issue of lack of marketability. who's on the open market is going to want to buy potentially a 10% interest in an LLC that's controlled by somebody else, where the income is not guaranteed and you have no say in management? That is a bit of a tall order. So by way of an example, here is it's a 12.45 LP interest, and this is a real life example to show you how discounted a minority share can be. So the underlying real property is worth over $13 million, but after the discounts are taken, the lack of marketability, lack of control, this appraiser decided to take about a 49% discount. And I was told by this appraiser that they felt that this discount was actually quite conservative. And I'll explain why they took a conservative approach. But you'll see that, you went from 1.6 million, which is a straight 12.45% of 13 million, down to 999,000. That is a almost $630,000 reduction in the interest. So as attorneys that advise trustees in administering a trust or in a probate estate, I suppose, we always need to think about liquidity. Is there going to be enough money in the estate to pay for all the costs? And namely, of course, paying the attorneys, right? Also a very important thing. But these appraisals can get very expensive. For example, for just a piece of commercial property, an appraisal could be $40,000. I say 40,000. Okay, $40,000. Thank you. And for an LLC or fractional interest, it could be $10,000 to $15,000. So why is it so expensive? Well, they're conducted by licensed professionals, usually with a special designation called an MAI. They have to look at a bunch of things like the structure, existing loans, revenue, capital improvements, vacancy rates, and also if you have a taxable estate, which at the end of this year, we may have a lot more taxable estates if Congress does nothing. You're going to be filing Form 706, and this appraisal has to be included in your 706. And one of the reasons I believe that these appraisals are so expensive is because they have to be defendable. And that is why the appraiser in my last example took such a conservative approach, is because they didn't want to have to end up justifying a higher discount to the IRS, because that obviously would end up costing the client more money. So their decision was, we'll take a more conservative approach with the discounts. The client may have to pay a little bit more out when doing a buyout, but it could save them money in the long run and time if they're not getting audited by the IRS. And also a word about valuation in a probate. So with a probate, as we know, the probate referee gets to value all the assets. And sometimes the probate referee needs a little help. For example, if the probate referee is valuing unique items like firearms or antique properties, you can go ahead and get an expert. And that's what I would also recommend if you have an LP or an LLC interest in a probate, is get your $10,000 appraisal and then provide it to the referee and see what he or she does with it. However, that LP interest that I'm currently helping with, that is currently subject to a probate. And in that situation, the probate referee declined to provide a minority discount. So we ended up with the 1.6 number as a 12.45% interest. Well, what is the problem, you would say? My decedent in that situation had died intestate, and his two intestate heirs are his mother and his wife. His mother is the general partner of the partnership. She's the one who gifted him that 12.45% interest. And now she's in a position where she has to buy out her daughter-in-law in order to get the full limited partnership interest back. So of course, my client, the mother, the GP, is arguing the $999,861 number. The daughter-in-law is going to be taking the position of the 1.6 number. So that's where you kind of have that problem where the operating agreement comes to the rescue. In that situation, my partnership agreement actually says if there is a dispute with the buyout number, the partnership's accountant wins. And who did we pick to do our appraisal? The partnership's accountant. So that one is still ongoing, but it really underscores the importance of having a really clear operating agreement. And I know, again, as attorneys that help our clients with trust administration, we don't get to necessarily pick and choose what kind of operating agreement that we deal with. But in a situation where the operating agreement isn't clear, your next best option is to say, hey, look, you pick up one appraiser, we'll pick one appraiser, and we'll meet somewhere in the middle. Because if you end up having to litigate the issue, it's going to cost everyone a lot more money and a lot more time. And in my client situation, she's a mom who lost her son. She's well into her 80s. Like, I do not want this to be the thing that kills her. So having a clear operating agreement is great, but if not, always think about compromising by having separate appraisers and meeting somewhere in the middle. Oh, okay. So more liquidity concerns. The reason why I'm saying that we're discussing some concerns because there are others, like loan acceleration, 1031 exchange costs, and supplemental property tax that Mike will get to discuss. But one of the nice things that the IRS gives us, if estate tax is owed, and like I said before, there is some anticipation that we may see more 706s coming up in 2026 if Congress does nothing, is because right now, as we all know, the exemption per person, the federal estate tax exemption is 13.99 per person. And at the end of the year, if Congress does nothing, we're going to see a drop to maybe about 7 million at the beginning of 2026. So if you have estates that are between 7 and 13 right now, this could be the year to do something about it. I'm not sure. But anyway, we have a nice code section, 6166, that provides an estate with an extension of time to pay the estate tax if you have a closely held entity that represents more than 35% of the decedent's gross estate. So if the majority of the decedent's wealth is tied up in closely held companies like LLCs, the IRS gives you up to, you can basically negotiate installment payments for up to 10 years. Your first installment payment is due no more than 5 years from the first anniversary from the anniversary of the decedent's death. This is designed so that families don't have to sell their businesses in order to pay the estate tax. They're giving you, the IRS is giving you more time to pay the estate tax over however many installments you need, up to 10 installments in order to meet that liability. Okay, advising a beneficiary. So a lot of what we just talked about was from the perspective of advising a trustee or a personal representative in a probate. But if you're advising a beneficiary and you're thinking, hey, I just inherited like 5% of my grandfather's estate, and he's got all these LLCs that are worth millions and millions of dollars. Well, that's the time when you kind of have to break it to them and say, yes, on paper, that looks really awesome. But the valuation, and then that's where you go into the valuation, is that the valuation isn't based on the underlying real property. It's based on, your actual 5% interest in the LLC. You have to talk to them about the discounts. And they have to understand that what they're getting is an interest in an entity where they have little to no control. A lot of times when people are inheriting LLC interest, they have no voting rights. They basically are just essentially, in a way, silent partners. They're just sitting there waiting for a distribution. They have no control. An analogy that I like to tell people is like, for example, if you inherited a piece of property, you take it subject to existing mortgages and liens. But the difference is with real property, you can just sell it on the open market, whereas your 5% interest in an LLC, there's no market for that. So the best, and if the LLC isn't doing well and not making distributions, the best that you can hope for as a beneficiary is that the managers decide to sell the property and you liquidate, and then you get your corresponding, 5% from the sale proceeds. I see that this issue is coming up more now as more people are passing away that have these LLC memberships. So unless the estate plan actually provides that certain beneficiaries get a specific gift of the LLC membership, one member's interest can splinter into even smaller percentages among children and grandchildren. And especially if the LLC isn't doing well, it puts the children and the grandchildren that inherit these interests in a really bad position because, as Vahishta said, there is such a thing as capital contributions. An LLC can make capital calls of its new members. So even though you have no control and no say in what happens in the LLC, the managers can elect to make a capital call and the members have to pay up. And if you don't want to pay up, then at some point, potentially the LLC can reabsorb the interest, or you can ask the members if they want to buy out your interest, but you're essentially, the inheritance is not worth as much as they initially thought. So yeah, and now I turn it over to Mike.
Thank you, Ritzi. I am going to try to talk about conflicts and hopefully avoiding them. There's probably a war story for each bullet point up there, everything I put on the screen. And I can talk about those if there's time in the Q&A, but I'm just giving you a mile high view, just so you can have issue spotting for when you're planning or going through administration, things to look for, things to anticipate, advise your clients about, and how to keep them out of conflicts. By the way, I did want to follow up on Tracy Regley's intro. She asked, do you file the BOI form or do you not file the BOI? As I had to look this up, as they were speaking. So apparently domestic entities are exempt more recently. I haven't formed an LLC in a little while, but for some time, for those that don't know, there's this federal agency called FinCEN, and there was a lot of hullabaloo about whether or not all legal entities in the United States had to report their beneficial ownership information with the BOI reporting, and the penalties were very large, for failure reports. So through some, I think, lawsuits, regulations, or whatnot. I haven't followed the whole story. I mean, it's been back and forth, do you file, do you not file? So as far as I know right now, no filing. So you can take that concern off your list. Let's talk first about conflicts between members and managers. I mean, often this occurs after there's a death of a family member, someone who's been intimately involved in the business, possibly managing it, maybe a majority owner. And then you have family members, as referenced by my colleagues, that are coming in that were not anticipated to originally be members. The relationships aren't there, maybe familiarity with the business isn't there. So there's lots of opportunity for conflicts between the members. So when we're talking about, buyouts, effectively trying to, separate out these members, so one person get their money, they don't want to be involved in the business anymore, even though it's a family business, they just have no interest in that. Sometimes you have valuation issues. What is the value of this membership interest? You can go through the appraisal process, get the, I'm thinking as a real estate attorney specifically about real estate, being the primary holding of an LLC, but it could be an operating business, and there are different ways to measure, the value of that business. And so, what is the value of that membership interest? Does everyone agree about that? Does everyone agree about the process for determining that? Is there a discount, based on lack of control, lack of marketability? So do people see eye to eye about that? Does the operating agreement provide for a method of valuation? competing appraisals, as Ritzi mentioned. You know, if you have two competing appraisals and the operating agreement doesn't say, well, we split the difference, you know, and just average two, you know, how do you reconcile these different valuations? Do you come to some kind of agreement that both of your competing appraisers, you know, select a third appraiser, you know, who's a neutral or a referee to decide between those? So some of those things are good to think about in how you draft those valuation and buyout provisions in an LLC agreement. You could go whole hog and get a whole committee of appraisers, but it gets very expensive, as Ritzi alluded to. Also, valuation, and this goes to kind of succession issues, is sometimes in buyout or even sale to third parties, I've seen LLC agreements that limit the class of potential purchasers for that business. You can see this in professional, you know, company, sometimes, you know, doctors, you know, medical professionals. That if anybody here has a you know, S corporation or something for their or professional corporation, you know, like attorneys, sometimes I've seen it limited to family members. People will define, you know, just the intestate heirs of a member as the only qualified class of individuals who can, you know, be a third party buyer of a membership interest. They want to keep it in the family. So pay attention to that. Let's see, management issues. And this goes to like business strategy and kind of knowledge of the people and the decedent who may have ran the business. Who's going to take over operations? I mean, you can have very pressing issues like after the death of, you know, the manager. Let's say you have a real property. Who has contact with the tenants? Like, who knows where the accounting records are? Who does the bookkeeping? You have tax filings due. There could be penalties for failure to file. You know, the tenant has you know, water heater that exploded. You know, who is authorized and in charge of managing, you know, third-party relationships for the organization so that you don't create additional liabilities for everyone? Who's in charge? Sometimes you have to go into court, you know, to get a determination, kind of like when you have a vacancy in a trustee or, you know, personal representative position. Same thing for an LLC. You know, make sure there's somebody there to step in who has some kind of institutional knowledge about how this business functions, and so that the value is preserved, that you know, you can have an effective transition away from the decedent's management, and it's not going to harm all of the members and the value of the company. So it's very good to have that, you know, hopefully in an operating agreement, but be able to establish that really early on, or know if you have to go to court to get an appointment of someone to take charge. Sometimes I've seen in LLC agreements also that when a decedent passes away, that the successor or the personal representative doesn't really have a vote in ongoing business operations, that their interest is solely for the purpose of resolving effectively the estate's interest in that entity. So there, you would have to take a look at the operating agreement to see, you know, what kind of control does the personal representative of the decedent or the trustee have to influence the decisions about how the company operates from there on out. Let's see. So, you know, when everyone is like forming LLCs, you know, advising about administration, it's really important to get a sense of, you know, what is the function of this business? How is it organized? Is that knowledge, you know, transferred to other individuals who may have to take over in the event of a death? Dissolution and partition. Vahishta talked about, you know, the potential for Involuntary dissolution actions in court. Usually you see those as a result of a deadlock. Sometimes a member just wants to cash out and they can't get that to occur. So they have to seek a involuntary dissolution. You see this a lot with kind of 50-50 ownership. Two owners, there's not a clear majority that can vote, to appoint a manager or make decisions on behalf of the organization. So you'll see involuntary dissolution actions in those circumstances where they can't come to an agreement about control. Also, as part of that, often you'll see accounting, cause of action for accounting, not dissimilar from like a trust accounting or accounting for an estate, but especially when you have a situation where the decedent was in control of finances, all the accounting, and everyone else was mostly a passive member or not understanding. So the people that will come later, they may have a lot of questions about like, well, what is the accounting for this LLC? Where is the income? How has that income changed over time? Where are the liabilities? Where's all the money gone? Maybe bank accounts have been opened and closed, and people aren't really sure, if there's been some questionable conduct about how the money was being spent. So often you'll see accounting action included with involuntary dissolution actions, and usually because there's a lack of trust. You don't have visibility or transparency into what has occurred with this organization over time. Vahishta also talked about, it just touched on the issue about partition. I want to talk about this just for a second because whether or not you have to seek a partition action, in my mind, in my experience, is based on client goals. So let's say, again, you have an LLC with real estate holdings and your client is a half owner of that LLC. Well, they may want to extract themselves from this effectively a partnership situation, partnership ownership with the other LLC members. But, if the property is sold in the LLC, there's going to be possibly, likely, capital gains. And your client may want to engage in some kind of 1031 exchange, defer those capital gains. They don't want to pay tax. They want to go their separate ways. They want to, buy a new investment property. They want to do a 1031 exchange. Well, you can't do that in the LLC. It's all or nothing. So if the LLC sells a property, you necessarily would have to have the LLC buy a new replacement property and continue this partnership. So again, if you're in an involuntary dissolution action, usually these members, they're not getting along already. You're not going to come to some kind of agreement, to invest in a new property together. It's unmanageable. It's highly unlikely. It may be possible, but highly unlikely. So if your client wants to take their money, go their separate way, not have to pay back capital gains tax, you have to get the property distributed from the LLC. That's step number one. So dissolution can do that. Obviously, agreement, to drop it out of the LLC. They call this process a drop and swap. So you drop it out of the LLC into TIC, to instant common ownership. And then you can do your separate 1031 exchange. Okay. So it would be strange, but not unexpected, that even if you go through this dissolution process and you get through your distribution of your TIC interest, maybe the other partner, they still don't want to sell the property. So you may have to force a sale through a partition. So I'm just putting that out there. That could be a natural result of where your client wants to go, what their goals are for the property. Then, it's outside of the scope of this presentation, but then you're dealing with the Partition of Real Property Act. It's been changed over the past few years. Now, all tenant in common ownership property, there's some necessary kind of buyout statutory language. There's like a procedural buyout process. It's rather cumbersome, not the scope of this presentation. You can watch another presentation on that, but just something to pay attention to. Ritzi also talked about liquidity issues, and Vahishta also talked about loan acceleration. You know, these liquidity issues are interesting because, you know, usually there are competing interests between members. You know, sometimes you have family. Some of the members want to continue ownership of property. They view it as a cash cow, good investment. They like it, they know it. But then the non-participating members, they just want their money. They just want to get out. But the LLC may have other liabilities, you know, other obligations. So, or there are concerns about, you know, what happens upon the death of a member. For loan acceleration, I'm thinking of a very specific transaction I worked on. The lender to the LLC and the purchase of the property, they have very customized credit agreement that came along with the loan documents. And as I was looking through it, there was this provision that said, and by the way, the members all had to contribute, you know, annual personal financial information to the lender, you know, to establish their financial creditworthiness year by year. So, and also that they had to keep a certain amount of assets in that financial institution's accounts. So they were really watching, you know, the personal value and liability with all the personal guarantees of all the individual members. Well, in the credit agreement, there was this one term that said, if there is a transfer of membership interests in the LLC that exceeded 25%, you know, of the membership interest, that was a default of the loan, and they could accelerate the loan. And so I'm looking at this, I knew that the members, you know, there's like 8 family members involved. So I'm thinking, so, you know, one person might want to give their membership interest to their kids, then maybe another person, well, then a third person, and all these people are in their 50s and 60s, you know, then one person has an untimely death. Well, now you're in default, you know, what are you going to do about that? So pay attention, you know, there might be, like, even as you're transferring interests, you know, seeing people, you know, pass away, give things to kids, you know, that's something just to be aware of. But it can cause a liquidity issue. And then now you're into question about, okay, can you get new loans? Do people need to get bought out? You know, does the property have to be sold to like satisfy this liquidity issue? And then how you manage, you know, other people's goals, say a 1031 exchange, or, you know, so all these issues kind of come together. Ritzi covered the estate tax issue. That can be a big liability for people. 1031 exchange, discussed on the prior slide. Property taxes, okay. Here's why I'm here today. This is the one I've fielded so many calls, you know, from people among you and outside of this room about property tax issues. And even before this presentation, you know, immediately before I was just talking with one of you about some of the issues that can come up here. I think this is a big pitfall. You can get in a lot of trouble. So I'm trying to tell you all about it. So yes, I do have a slide. Let's see. Okay. Just relating to LLCs, this is what you have to know about property taxes and LLCs. Really bare bones. If you go to the BOE, Board of Equalization website, there's a lot more information, frequently asked questions. I'll point to a slide there at the end. But this is just the starting point of what you need to know. This is going to be becoming more important, you know, in this Prop 19 regime, post Prop 19 world, because for you estate planners, you know, avoiding reassessment of property, especially investment property, not, the personal residence. LLC, in my view, is probably the most utilized tool to accomplish that through kind of a series of transactions. Again, the topic of a different presentation, but you're going to see a lot more LLCs, in estate planning, and you may get caught in a certain situation where somebody untimely dies, and there are additional liabilities, for property tax or unexpected reassessment. Just because people are going through the process, it gets cut short, and there's going to be more property tax to pay. It can be a lot of money. That same family I was talking about, the credit agreement, they got hit with a supplemental property tax bill of $200,000 recently, and they weren't necessarily thinking to themselves like, hey, we should be saving up until the bill comes. It could come years later. In their situation, I think grandma died in 2019. We got the bill last year, 5 years later. But the other twist to that is there was a penalty on top of that. I'm going to talk about how to avoid that penalty, even though it comes 5 years later. It's a lot of money. It's tens of thousands of dollars. So LLCs and property tax reassessment. There are two events of reassessment that you have to understand and know about. And I've defined them up on the slide here. So the first one is change of ownership. Okay. Think about like this. Mom, puts a property she owns, whatever interest in property, it could be 1% property she owns, she could own 100% property, it doesn't matter. She puts her interest in the property into an LLC, okay? So she's the original member. She's like the original transferor. From that point forward, if there are any interests in that LLC, membership interest in the LLC transferred, those have to be kept track of. Because once you have a cumulative change of over 50%, that is change in ownership. So she gives 10% 1 year to the kids, then 10% another year, 20% the next year. Once you exceed that 50% threshold, and she's no longer, and it's not there are exceptions here, original owner, she's putting it under her own trust. Okay, that doesn't count. She's putting it into another LLC where she's, 100%. Okay, there are some exceptions here, but what you have to know is if she's gifting away interest in the LLC, or she dies, and that results in a beneficial change of ownership exceeding 50%, that's going to be a reassessment event. Okay. Second category is change in control. It's when someone becomes a majority owner who was not a majority owner before. Also a situation, you can have two LLC owners, 50-50 ownership of the LLC membership interests. If one person gets more than 50%, that's change of control. If a majority owner, let's say somebody is already a 70% owner of an LLC, and their fellow member passes away and gives them 30%, their 30%, they inherit the last 30%, not a change of control. They were already the majority owner. So, but these are the two kind of situations that you have to know about for triggering reassessment of the LLC owned property. And like I say at the bottom, all of the interests that the LLC owns is reassessed. So if, for instance, if an LLC owns 50% of a property, only that 50% that the LLC owns is reassessed, not the other 50%. You have to pay attention to that too. I've seen notices of reassessment that The assessor thought that, oh, the whole interest in the property, like I've seen mistakes by the assessor's office that they would reassess the whole property, even though, because they misinterpreted the rule. Because they say, well, all interest in real property owned by the, and they think, oh, it's the 100% of the property just because the LLC had a small interest in, no, it's only what the LLC held is reassessed. Next slide. So how did the tax authorities find out that there's been a change in ownership, change of control? First bullet point, the BOE 100B form. It's a form that you or your client, the LLC owners, voluntarily fought with the BOE. So it's a voluntary reporting mechanism. I'll talk about that more in a minute. Annual income tax return with the FTB. There's a section on Form 568 with the FTB, Section I. If you look at it, I mean, just on its face, it's very convoluted. It does, like even me looking at the question of the form, is there a change of ownership? And it doesn't read very easily or clearly. Your clients will probably not understand what's being asked. I think even accountants answering this question, might not follow up with your client or properly get the information to understand what's being asked or whether they check the box on there. In some situations where I've had clients come in, they've had LLC or partnership ownership of property for 30 years. There's dozens of, transfers, or inheritances, assignments of membership interests. You look back on the filed 568 income tax, and at no time did they ever check yes. Yes, there's been a change of ownership, change of control result, but in theory, it could be reported, by the client or their CPA, tax filing helper, that would occur. It would filter back to the BOE, and the assessor would also coming up on our time. I'm gonna hurry. And then the assessor can also get information publicly or through a personal property tax report about some kind of change. This is the BOE 100B form. I implore you to look at this form. It has to be filed 90 days within a change of ownership or change of control. If you don't file it within 90 days, there's a penalty. I could talk about the penalty, that would take more time. If a client, their parent passes away, they own an LLC, it has real property control, they call you on day 60, you have 30 days to file this form. Like, get it done. It's urgent. It's not one of those things that can wait. If you don't make the deadline, that's your fault. It's not the client's fault. There is a process for abating the penalty through an appeal with the local assessment appeals board. You don't want to go through it. It takes a long time. There's uncertainty. You might have to report to your malpractice carrier. It sends up thousands of dollars, or you can't pay that out of your own pocket. No, you don't want to do that. So know that this form exists. Know that you have to file it. 90 days. It's a hard deadline. You could submit it electronically now, fortunately. Yeah. Oh, if you don't know enough information about who's supposed to receive the interest in the LLC, it doesn't matter. File the form. You have to explain why you don't have enough information in the form. And then once you do get the information, you file an amended form within 90 days of discovering, like, who's going to get the final LLC distribution. We don't know, but late filing penalties, the abatement of the penalty, revenue tax code. You guys will get copies of these slides. You can take a look. Like I said, BOE website is very helpful about this. There's a lot of explanations. There's frequently asked questions. If you have to go back. It's very convoluted language, like I said, but feel free to give me a call or buy me a beer. Questions? I think we're on to questions, but
Yes, we have a.
Okay, just a few
Do we
questions.
have any online?
No, no, we had any on them.
Do we have any in the audience?
Yes, yes.
Turning back to the personal guarantee that you spoke about. One of my professional trustees are now members of LLCs. And so are you seeing language in the operating agreement that states that if it's a trustee of a trust, the trustee isn't guaranteeing his or her personal assets, but instead the assets of the trust? That's question number one. And question number two, are you seeing lenders and landlords pushing back on that?
So in regards to question number one, no, I don't see language in that sense, but the trustee can make that determination as they're negotiating the guarantee. So guarantees, when you're dealing with a landlord, you can always negotiate that, and you can limit the guarantee to, let's say, 5 years of the assets. I'm sorry, 5 years at a time. So that guarantee expires within that 5 years. That's one way. And the other way, lenders will make that determination. If you want that loan, you sign whatever the lender is giving you. Unless you have worked with that lender numerous times, you have a boatload of money, and you have series of properties and you've worked with that lender numerous times, then you can negotiate a provision of that personal guarantee. But beyond that, when it comes to lenders, it doesn't matter. You can't tweak it to say it's only limited to the assets of the trust.
Yes, a lot of clients nervous.
That's why personal guarantees are that's why I'm saying people, especially when members are asking, members are obligated to provide personal guarantees, they become incredibly nervous. And in commercial leases, for example, when I'm negotiating the lease and I see personal guarantee language, some of those languages are incredibly broad. They'll tell you if you sell an asset, if you sell your, like, for example, your primary home, you have to notify the landlord before you do that, and you have to get the consent of the landlord or lender before you do that, because it impacts the guarantee. So.
Just to follow up on that, like I was talking about the agreement example, when we were doing gifting, we would approach the lender upfront and ask, for clarification, or even kind of a waiver or allowance for certain situations. So, but it's negotiable. Most creditors, they will want that for their own protection, but it's good to have the conversation to try and define those limits. Like, where are we talking about? Are you feeling go after the trustee?
It seems like the trustee would want that language in the operating.
Well, as long as the creditor, also, agrees with the overall situation, because it wouldn't necessarily stop them, if there was a breach of contract action. I mean, and they just name the person personally. I mean, you see that a lot in litigation, regardless of the actual alter ego liability, regardless of, whether or not there's some personal individual conduct. I mean, you can use that as a tool, like as a negotiation or leverage tool to try and come after the individual. So you see that all the time.
Just my question goes to series LLCs, which I realize California does not have. But what if you have a client who's coming in, they're starting to build their portfolio, they've got 6, 8 properties, and they're balking at having to file separate LLCs here in California? What do you do in that case?
So in those cases, I usually work with their CPA to figure out how many of those properties, and I look at exposure level, right?
Mm-hmm.
So you look at, so if we're talking about commercial pieces of property, I look at, is it a warehouse? Is it a retail store? Is it a big shopping center? And then I work with the CPA too, because the CPA in essence will look at the tax implications, and then we'll figure out how to minimize the number of LLCs. But honestly, you can't get around it.
Yeah.
You just, unless you go open up your LLC in a different state, but then you're paying, you still have to register with the Secretary of State and you're still paying those taxes. So what's the point? You might as well create it in California.
Especially a hold the real property.
Yeah,
You have to have
yeah.
a domestic
Yeah.
registry. I mean, honestly, the advice I usually, I mean, especially if you're talking about like a single member LLC situation, I mean, you have to have a serious conversation about like, what are you paying for? You know, are you paying for privacy? Well, they can still look on the Secretary of State website and find out that you're manager or owner. Like, you have to go through a lot more effort to like hide your ownership. So if you're talking about liability, I mean, my experience is I definitely see alter ego liability judgments. You know, those happen, especially for a single member. You know, whether or not the court is going to follow I think it's like 13 criteria for finding out, you know, they might just say like, hey, this smells funny, I'm finding alter ego liability. So, you know, allocating that money to more insurance, you know, where someone else is going to pay for it, and just have it individually named, you know, but the LLC is a tool for some purpose. And you have to understand like why you would put it in there in the first place.
All right, we'll take one more before our break. There was one in the back. Oh, okay.
Because I had heard that the LLC was a vehicle that you could protect, like rental properties. I have a client, 57, like one extra property. But apparently that's not the case with the change of ownership. The change of ownership will kick it into the reassessment period that is at. So it's no longer a vehicle that you can use, correct?
Only to those thresholds. It's okay to those thresholds. If you held it tenants in common and it's not your personal resident, you know, under Prop 19, like it will get reassessed.
Right.
So it can help. It's a tool for trying to navigate avoiding that reassessment, but you have to understand what those thresholds are.
So up to the 50%, we could, like, you know, parents, 100%, but then they got 3 kids, as long as they meet the threshold. But as soon as the second parent dies, you reassess.
Well, again, subject of a different kind of presentation, but the entire idea is you're putting it in the LLC, you're transferring, you drop it out of the LLC, then you put it in again, more transfers, take it out, you know. And there are risks there, you know, step transaction doctrine. But
Can you repeat what the question was?
what's that?
Can you repeat what the question was?
Oh, like, is an LLC like a vehicle for avoiding reassessment, especially with those thresholds that we talked about? And the answer is yes, it can be, but you have to be very deliberate about how you're strategizing to make those transfers and when they will occur, either by death or gift. Like I said, I also alluded to the fact that, you know, you can get caught off guard. Somebody has an untimely death and you're going through this process of, you know, a series of transactions. So you might get caught and there will be a reassessment of the whole property, not just the percentage that would be in a TIC.
All right, I would like to thank our speakers. They will be around, so you can catch them at the cookie table, or you could buy them a glass of wine
There we go.
for free at the end.
There we go.
So please enjoy.
Okay.
All right.
Well done. Well done. Yeah. Sure. Really is about I would just say, yeah, if you're just keeping the person, like, you can't transfer it. But once you start changing, like, that's right. It's like, I made that mistake early in my practice. I was like,
Like everybody's fighting here.
yeah. Yeah, the backstory, I mean, this form has been like the bane of my existence for like a couple of years now. And it all started, I mean, like there's one experience that started this whole thing. Like, I was working for someone else, and in 2019, I had to handle like the first big trust admin, like full 706, and like, we're going to like $80 million, all these LLCs and stuff. And so yeah, I was like, okay, and the person I was working for, like, he had done this stuff before, but he was like, hey, I got in charge of like, okay. I had never, up until that, I had been doing for years. Strangely, I never had an LLC like in any of these years. So when I first thought about like reporting stuff, like my general impression is like, okay, well, it's a little bit slower, like be very deliberate, we have appraisals, we're trying to figure out like, are we selling things, who's getting things, so it's just like, oh, this will take like months and months.
Wait, I don't have a property here, that's why, I was like.
In a certain way, the client only gave us like 60 days after that. So we had this limited window that I didn't even.
Yeah, it's a minority interest, less than 50%, we're good.
Year after that, we finally filed forms, but that's when we did the LLC. So I'm like, okay, LLC is when we filed forms. I was
I'm just saying, I need to get water.
I was like, okay, this is now I'm recording the official change. Seriously, last year is when we got and supplemental tax assessment. It took 5 years to filter through, even though we filed a year late.
Suggestion, because I don't know what to reserve, that's like.
Yeah, so even, I mean, I didn't have time to go into it, but now I like spreadsheet out like estimated supplemental property taxes. I've had to estimate out for my lawyer, with the penalty. So he can report it to his malpractice carrier. And then, but and then if you like that form has now caught me off guard twice, and I'm waiting for the second time. And so I told you about the first one. There will be another one that might be like 2 or 3 years from now.
And you would think there'd be like a mercy rule or some sort of exception, or like there's litigation.
What's crazy is like for a time, only for like a year, they shared me which is like insanity. It's like you don't even know. You don't even know. And then people start going, it's like, oh well, should the CPA file this thing? And then like, but it's
Okay, I have a stomach ache.
anyway.
Stomach
Sure,
ache,
yeah,
I
sorry.
appreciate it.
Hi, yes. We met that's how it's okay, so I probably see you there, yeah.
So I'm thinking of like, well, what does that valuation look like? Because this is what
We know, obviously, that there's been, and who's keeping track, right? Yeah. They already gifted it to you, or was it? So they formed the LLC, they were 50-50, and they were. Yeah. Okay. Yeah. So here's, I would have to double check this because this question has come up like in the past year. I think the BOE does not recognize disclaimers. End of story. Like, it will count as mom getting it and then transferring it to the kids. From the BOE point of view, the disclaimer does not, like, because the disclaimer happens after that. The BOE is looking at that exact depth point of time. Who is the new beneficial owner, regardless of what happens later? So I think, I mean, I would just have to guess that but look at the BOE rules. Like, I don't know which rule it would be. There's definitely something about like disclaimers. They've definitely addressed this somehow. I don't know, but and that might just be from some other like perspective. I'm not sure. You would have to double check whether it applies in an LLC context too. So there's like two layers to this. One, do they recognize beneficial ownership as relates to like disclaimers? And then step two is like, does that also apply to LLC legal entity changes? There's like two separate issues right there. Yeah. Yeah. We have talked. I know. I'll tell you how to handle. I will tell you how to handle. Let's just step back. So when mom and dad formed the LLC, they deposited 100% ownership. Or they only had 48% each when they deposited, and then the two kids deposited. So that size goes into bypass trust. No exceeding 50% transfer. So that you haven't met the threshold. Oh no, that would be a change in control. Now she's 98%, so she became 40. It would be reassessed. Oh, 100% reassessment if it goes to that. That's what it is. No. If it goes to the children, no reassessment. Oh, right. But if they don't, yeah. If the disclaimer is valid, the BOE is okay with that. No reassessment. But if they say like we don't acknowledge disclaimers, then it would be. This is why there are all these weird pitfalls. It's like which risk am I taking? Am I TIC something will get reassessed versus like stressful rating? So then the planning phase is just like, where are we? Where's the risk? We might get caught off guard. It was not connected. You would push a button and it wouldn't go. It wouldn't go. But now it's connected.
Okay.
And so I guess the connect button is something that
Okay.
I mean, you can tell it like, hey, can I get a drink? Can you buy me a beer?
You might just aren't out yet. We're gonna share that.
Yeah.
I talked to the attorney. I'm like,
Primary.
Not a good idea. When did they do that? A while? So Thursday is available. Yeah.
No, I said.
Yeah, I mean, like somebody that's not here. I have. Because it's happening.
Laptop right on the table. Like the portable.
We don't use it for
It can be, yeah, I mean,
as you saw. Yeah. Like twice.
Yeah.
Okay, yeah.
I mean,
I'll be your tech person.
I think, I mean, I don't.
I know, this is your camera. Yeah, that's the camera.
This would be really.
This is, I didn't feel like you were set up very well, Sarah, about that, you know, like, because you've been so uncomfortable to like go back and
I
forth.
know, but
You know, but you have to do what you have to do.
Yeah.
How's that?
Okay, is that still good?
There's all kinds of.
Yeah, I can also put that.
this is just an extra battery.
Okay, okay.
So this
But-
white cord right here,
Yeah,
that's
yeah.
ours.
Okay, got it, yeah. Thank you.
Like,
So you got
No, I'm so glad to. You guys, I know you didn't need us, but we did.
No, I like to have it for okay.
So it's popping up now. when
Yes.
someone's in the waiting room. I don't
Okay.
know if it's mode, I guess.
I figured we could share.
It's working fine. I mean, they can hear great. I think it's used to microphone center. I tested it. It's working good. But she's watching her song. Follow up for me.
This way. There's some
It should have started at 3:15.
I was gonna go to the restroom.
Yeah. No, I'll leave.
Yeah, 50% is not giving us that. That's a good way to go.
Yes, I'll be around. I had a really crazy like beginning of April and now I'm starting to calm down.
And you can double check that. Only 50%.
We've been keeping the door locked because we've been getting some like weird,
And that would be
yeah,
the
some
same.
people kind of moving around. I would love it. I would love it. Please. I need
That's good for you. Because
my
it's
office. You came back from a vacation, that's all. Okay. So. I'm a little bit worried. Well, that's why. Yeah, you know, get the presentation, that's why we have
Yeah,
this.
I have the opposite.
Yeah, about it right now.
No,
Right? But I was like, what do you want to do?
It was so hard because it's so dark.
I know, yeah, I know, it's, it might be the, there's too much light in here. I don't know, that's why I was worried about that. Well, this is the, so hopefully that's it.
They should be in there with us, but I was like worried when Tracy was over there. I was like.
Okay, appreciate it. Just let me know.
Do it. Do whatever you want. I don't know. See what's in here. If you could maybe find the. I don't know, whatever. Okay, it's yours. No, I'm using it. I don't know. If you would always sit there. And I was just like. I know, and now we can't see the ticker. So I'm just gonna have to look at it. On my license. Oh, okay. Yeah, I can't wait to hear. This party started, yes, like going over there. I don't know who I found over there.
We're going to get started so we can stay on track. First, let me start by saying, I know it's hot in here. We have tried to get the air working and it just isn't, so we've opened the doors to at least try to get some cross ventilation. I'm sorry. Please feel free to take off your jackets and ties and not anything else. I would like to introduce our next set of speakers, which, by the way, after this event, we have outside that we can use for our after festivities, which will be cooler. So our next presentation is going to be a deep dive into AB 2016, which I am very excited about because I personally have a lot of confusion around this area. So I am excited to learn about it so that I can hopefully advise people. So we have Amanda Sinclair and our very own Esther Kim. So please give them a warm welcome.
Is this not working?
It probably is disconnected.
There we go. Oh, there we go.
Perfect. Sorry.
Okay.
Little technical difficulties.
So for today's presentation, we have a lot of material to cover, but we are going to focus on the areas that are highlighted because we feel like those are the most critical pieces for you to be able to understand this new law. So we're going to walk through the legislative changes that have been brought about by AB 2016. We're going to present the unique issues presented by this new law.
And then we're gonna go over a hypothetical, going through section 13151, which is the new law. And then we're gonna touch on some estate planning considerations and also some title insurance considerations. You are going to be receiving this whole slide deck, which is it's really a resource for you. And I'm sure that you're gonna wanna go back to it to be able to refresh your recollection of our presentation. And what was I gonna say?
Well, the non-highlighted items, we'll just split on, so those aren't quite a steep dive.
But this law is, you know, is one of the, I think, one of the largest changes that has happened with probate. And so if you are in the area of practicing probate as well as trust administration and trust, this is something that you will definitely need to know. So let me just get to the conclusion. Trusts are not dead after April 1st, 2025.
Okay, all right. You can all go to sleep now.
No, absolutely not. Okay.
Oh, well, okay, you guys heard about me and
then
you heard about her.
Yeah. Okay, so depending on how the presentation is going, we are going to be, our plan is to stop at each section and see if there are any questions. If we are getting sort of bogged down, I think then we may need to reserve the questions to the end. So with that being said, let's keep going.
Okay, and just so you guys know, today the Judicial Council was supposed to release, or yesterday was supposed to release the new forms to be published next week. They are not yet released. So
Surprise.
Yeah. So when you get the presentation, there's links within it, so you guys can go and look. And we do have the proposed forms here, though. Okay.
And here's our disclaimer.
Oh yeah, you want to display?
Yes. So as you know, this is not any advice that you can rely on. This is for educational purposes, and there is no client-attorney relationship because of this presentation.
All right.
Okay, now, go ahead.
All right. Okay, so we're going to take this new law, which actually isn't a new law because they rely on existing statutes, and just turn them on their head and look at it from a bunch of different perspectives. So first, let's look at it from the legislature in California. So this law changed all of these existing statutes. So if you have used them in your small estate arsenal in the past, you're going to have to learn how to retool them. Okay, then we'll go through that. So here is the voting record. This was not a squeaker. This went by 100%. So this is here to stay, guys. So all right, so legislature has bestowed this new law on us, and we'll go through each of those sections to kind of see where we were and where we're going to. All right, so first section is 13100. So as you know, in the probate code, this chapter applies to small estates, which are an exemption from what we tend to call the formal probate process. So 13100 has just a little bit of a change there. It says that may be included in a petition filed under section 13151. All you need to know is effective April 1st, everybody needs to run back to their office and change their 13100s just slightly, okay? So it has that new language. And like I said, you'll have this on, you know, as a reference point to make those changes. All right, so for 13100, what does that mean? In addition to the property that is included in 13050, which we'll talk about in another second, the calculation for a small estate now exempts the property that you can use in this new petition. So the spoiler alert is that that is the decedent's primary residence if it meets certain criteria. So this is a big change. All right, so refresher for 13050, remember you will have this. So You know, so this is, you're doing the same analysis as always, right? You're pulling out these little things to see what you can make go outside of probate and then look at this new section. All right, so if you also have this in your practice, you know that whenever you furnish a 13100 declaration to a custodian, you attach not only a death certificate, but this section 890 values, which are found on DE 300. So this was supposed to be released yesterday. It was not, but these values will all be new starting on April 1st. And you go, wait a minute, we're past April 1st. Yes. Okay, so we do not know the new value, okay? So last time we went from, for small estates, we went from 166, 250, right? 250 up to 184, 500. So odds are we're somewhere above 200,000. This is a, you know, linked to the inflation rate, which was, you know, a little bit hyperinflationary. So, so just make sure whenever you do file a new or provide a new 13100, anytime after April 1st, you put in that new language and you're going to attach this new DE 300, which has the new language or new values on it. Okay, so then we're moving along. So again, this is what you have to put in your declarations. Who knew this was applying not just to primary residence, but also, you know, these related procedures. So just make sure this is exactly the language you need in your new declarations. Okay, and so bringing this all together, that means you can pass a primary residence if it meets the requirements. The 13050 exclusions that we just did that really warp speed review of, and also whatever you have in your small estate. Okay, all right. So that means, you know, that's a lot of property that you can pass outside of probate. All right. 13150. So this is where the big changes are coming in. We have now, you'll see that the legislature is now referring to primary residence everywhere. Prior to April 1st, this statute applied to both real property and personal property. So now this statute only applies to personal residences.
Let that sink in.
Yes. All right. So if you have, I don't know, I've had them over the years, a timeshare, a 1% interest sitting outside of the trust, you can no longer use this petition to pass that. So just make note of that. And also remember, primary residence is stated that it does not have to be, let me get back there. For purposes of this chapter, primary residence is not limited to the decedent's residence at the time of death. So this makes it all confusing. Like, what are we talking about here? Okay, so as you know, a death certificate, for example, is reported according to the informant. So it has your usual residence. So the death certificate may not match primary residence. So you got to do a little bit of review. All right, now here's the petition of information that you have to include. So you'll see, and we'll go through this in more detail, but of utmost importance is that you notice in B here, you have to serve this thing within 5 days of filing. Okay, so that's I don't know of anything else like that, right? So, all right, so here is what those changes do. Limits it to the primary residence, and the people who can bring the petition are the successors of the decedent. So you go over, flip over to 13,006, and that is the definition of successors of the decedent. If you have a will, it's the beneficiaries or beneficiaries, right? Or if they die intestate, the intestate heirs, okay? So this is all important to kind of understand who has standing to bring this petition. Uh-huh.
One thing that's really important to understand is that this is a court process. This is not some form that you fill out and you file it with the recorder's office, or this is really not a, I don't believe that this is a layperson friendly process. So the idea that, you know, we're making this so much easier for people, and that this is, you know, this is the kind of information or misinformation that I think is going to be out there. Like, I don't need an estate plan. I can pass my residents doing this really simple petition. They just don't really know the ins and outs that we're walking you through of all the requirements that are needed, including appearing in court.
Just kidding.
So just wanted to make that clear. Okay.
So, okay, perfect. Thank you, Esther. So like I said, we're taking this from all different perspectives. Right now, we're really focusing on you as a practitioner, understanding the ins and outs of how this is going to work when this comes into your office. Okay, so again, we have that 5 business days that you have to serve it after filing. It also is important for you to determine if a probate has been filed. If it has been, you have to get written consent by the personal representative. And you have to, peculiarly, you can have more than one primary residence as long as you only have one in California. Weird. Okay. At first, lastly, the first day that any of us can file one of these petitions is 40 days after April 1st. So that would be Sunday, May 11th, which may be Mother's Day, but no, we'll do it on Monday. Okay. And then always be sure to note these other notice rules, because decedents' estates, you still have to serve it more than 15 days before the hearing as well. So it's all very intricate. Okay. So here are some of the cures that we thought about as far as that 5 business days, because some counties, right, you submit something for e-filing, you may get it back 3 weeks later, but they stamp it the date that you received it. So, you know, that's not going to work. So they always encourage us to put a note in that field for the e-filing clerk, message for e-filing clerk, if there's a statutory limit on why they need to expedite processing. So I would recommend putting language in that field for Contra Costa County. It won't hurt for other counties. Whether or not they read it is a question. You could possibly serve it twice, once when you file it, and then again when you get your hearing date and proof of service. Unsure if that will work for all counties. You can get waivers of notice from everyone if they are able to execute such a document. And of course, you can file in person in many counties and just get the hearing date then. So you're not totally at the mercy of just waiting for that return date. Okay. Moving on. So here are the contents of the petition. So what we have to do in this new scenario, and this is where Esther is sure that, you know, if you're just coming into this blind as a member of the public, you have to attach an inventory and appraisal form to the petition. Okay, so it's hard enough for me to get one back in a, you know, reasonable amount of time. So just imagine you have to do that, right? So, and then also the house, you have to have it, here's the big kicker, less than a date of death value of 750,000. So that will vary from county to county, and we'll look at some statistics here about where this will be more prevalent, but it still could happen here. And again, like Esther was talking about, the public education piece really is going to be important. So,
The other thing about the INA is that you need to have a probate referee do the valuation. And so, I mean, here in Contra Costa County, there are just a handful of probate referees who are being assigned on regular probate. So now we're gonna add in these additional types of petitions. And then what if the petitioners don't like the value because, oh, sorry, it's just over $750,000. Are they gonna shop around for another probate referee? Are they going to threaten the referee? I'm not gonna pay your fee until you lower it down to the appropriate price. When this legislation was going through, the probate referees were having comments about this particular law and their concerns about that, which were promptly ignored and, you know, passed right through. But so just know that this is potentially an issue for our probate referees who are already overworked. And so getting that back and having it at the right value is going to be very interesting.
And I just imagine some of the smaller counties, so sometimes you have one probate referee who's covering many different counties where this will be more prevalent. Yeah, this is going to be tough. Okay.
More good news.
More good news. Okay. So, you know, just think of it as one of your additional arrows in your small estate quiver, right? Okay. All right. So even more, so this is where we get the $750,000 valuation. And interestingly, right, this is the new law starting April 1st. So you can no longer use this for personal property if you've used it or other real estate. So we're kind of stuck now with this new law. Okay. But this will be adjusted for inflation every 3 years eventually, right? Okay, so here is how it'll kind of be gradated here. So before 4-1, if the primary residence was up to this. So this is all, so we're kind of recasting back in time how you can administer things. And really the meat of this is going to be in how you're describing this being the primary residence, which we'll get into. Okay, so there's that nice procedural note that you have to get that INA. And then, yeah, here's the thing about this. So we do not yet have the forms. They were supposed to be released yesterday for be published next week. So up until those forms are released, which will be mandatory court forms, you'll have to craft an attorney drafted petition. Okay, so just watch it. That's why we said we can't guarantee any of this because we haven't seen any of it come out. But if you do have to draft an attorney drafted petition, just follow the statute because there's certain findings that the court has to make in the order that have to be covered in the petition. So like I said, we have to make sure that we have the correct successors of the decedent and they all have to be there. Okay, because the petition has to be brought by the successor or successors of the decedent, and it has to be the primary residence. Okay. All right, so here, like we said, so there's a link for you guys. Okay, and I know this might be a little bit hard to see these next slides. So this is the old form. And like I said, you have all the links here of how to get the new ones, but here is the new form. So those highlighted are the changes that are proposed to the old form. And most important there is that number 11. And this is where you have to allege all of your facts. So there's no room on that form. So you're going to add attachment 11 to this thing. And you're going to allege both what the decedent's interest in the property was, if the petitioners have any interest in the property, how you determine that this is their primary residence, and then furthermore, if there was a conservatorship of the estate or guardianship of the estate, there's more check boxes. So just work through it according to the facts of your case. Alrighty, and now we have the court order. And again, there, like I said, there's certain findings that the court has to find, and you guys will be able to read that when you can't sleep one night. Yeah, so, as we said, right, you have to clarify, this has narrowed the scope of these petitions. It's made an old thing a new thing, that this applies to primary residence. There's no more checkbox and personal property. You have to use that in a 13100. So just be careful when you're doing that. It's just like any of those other court forms, like capacity declarations. Don't miss a box, right? And so here is the new form. And you'll see, this is something that is eventually going to be recorded because it is changing title to real property. Okay, and this is just, we got rid of, this is just confirming there's no personal property included in these. Okay, so these are the legislative changes. So you guys are going to be able to speak intelligently to this, right? Yes, no, we can't do this. No, okay. All right, so that was the legislative changes, just so you guys kind of have the foundation of what we're talking about. And I think this is, if we have any questions, we really want you to be able to understand what we're talking about first. Yes.
So my question is, I've used that prior iteration of the form with like random, a parcel of land in Kern County that doesn't amount to anything.
Yeah.
Are
Exactly.
those individuals now forced into a probate for those parcels? Like those random ones that we used to use this procedure for?
So, yeah, so we're gonna go through alternatives now available in a little bit, available to real estate, but yeah, that's exactly what I would use it for, that random, that they bought the lakeside property for, at Lake Shasta or something, yeah. So you're gonna have to use one of the other procedures available, not this one, yeah?
If somebody dies between now and when the numbers come out, what are we supposed to use as the placeholder for this policy application?
So you either have to draft your own petition, but remember the first day.
Is it no longer 184,500? So do we just leave 184,500 until a new number comes out, or what do we put as the value?
Yeah, so I would put it right now, if you had to submit something, I would use 184 and just some language as adjusted on 4/1 to be published or something. You can always put something like that, but we don't know what the value is. And the state legislature decided not, they usually publish those forms, but they thought it would be too confusing to the general public to have this period between April 1st and May 11th. That we have this weird situation where you can only use this thing for 184,500 because you have to have at least 40 days from date of death, right? So if your decedent died on 3/31, you're still using 184,500. If your decedent dies today, you have to wait 40 days and just hopefully they have it published by then. Yeah, but I don't hold my breath on these things. Yeah. Okay, so we all feel good. Okay, so let's talk about. Yeah. Okay, so next up is, let's see.
Try it again. Just try it again. No? Okay.
Oh, yeah. All right, perfect. So let's look just really quickly at some of the unique challenges of this new law that you may not have thought of, right? Yeah, okay. So you may bring this petition, but you're not required to. It's not always going to be appropriate, right? So second of all, bringing it all together, like I said, we can have a primary residence up to roughly 200,000 plus those other exclusions. So that was what the legislature was really aiming for, to make that easier for families. And then there is a big fear, though, that if you have a probate, the house will get pulled in, and we'll talk about that a little bit more. And then here's something that you maybe not think about regularly when you are using those small estate procedures, okay? So California Probate Code Section 13156 clearly states that if you take property from a decedent, you have personal liability up to the date of death value. So that wasn't as big of a deal when they were very small estates, but now we're talking about, we've just talked about it, you could transfer $1 million. So when you're counseling people, you need to let them know that there's this possibility that they may be on the hook for some of these things. So as part of your process, you need to evaluate what debts might be out there. Is this a decedent who hasn't filed taxes for 15 years, right? Because when you go through probate, we have a procedure for clearing and prioritizing debts, right? And a lot of us who practiced in 2008-9, right, when we had underwater houses and all sorts of things, we got really familiar with the priority of debts. Here, you know, you're out on a limb. You're taking the good with the bad. And that applies not just to secured debts. It's credit cards, it's tax debt, it's all sorts of things. Okay, and then of course, the big $1 million question is determining the primary residence. So one thing that I would look for, and Prop 19 always seems to come back in on these things, right? Look where they had that homeowner's exemption filed, or did they move it? So frequently people will move, to an assisted living or live with a child for a little while. But if they still have this homeowner's exemption, it's probably pretty good evidence. The IRS will look at where you spend most of your time, which may not be appropriate when you're older. You can also look to where they're registered to vote, federal and state tax returns are being filed from, driver's license, car registration. So you're going to have to develop facts, kind of like when you file a spousal property petition, you have to explain the why behind it. You're going to have to explain why this house should be considered the primary residence. So it won't be as big of a deal if you have a homeowner's exemption filed and it's clear they had one parcel of real property. But if you have multiple properties and they're moving around and this stuff is all muddied, you're going to have to make a decision, right? And like I said before, the death certificate has your usual residence, and that's not always your primary residence. So, you guys have this, you'll be able to put this where on attachment 11. Okay.
One thing also I want to bring up is we're going to talk about, we'll mention it later, but unlike a probate where you have statutory fees, we're always thinking about how are we going to get paid, right? Well, this is going to be an hourly situation. So what if you take on a case and the facts are a little iffy on the primary residence thing? And you take it on hourly and you say, look, I think this is a shoo-in. And then you petition the court and they're like, yeah, no, we don't think that's the primary residence, denied. Then are you gonna have to then go take it through a full probate? And then how do you explain that to the client? So I think this could be a potential trap for us as practitioners, because there's no, I don't know if there is a sure thing, and clients want a sure thing. So I think this is where you have to be very, very careful about evaluating the type of case that you would take through in this procedure.
And I always like that you have your clients are the unreliable narrator, right? So independently verify things. Okay. Perfect. So again, this is legal stuff. Couple of quick questions, or you guys want to move on? And online also. Yeah, Tracy.
So we filed this in county question. Some courts are setting way far out. So if you're not going to have a hearing on this petition for 6 or 8 months,
10, 12.
there's nobody in charge of that in the meantime. And then if it does get denied, you So there's no expedited process to rule on these or is it?
Okay, so the question for those of us joining us virtually is, what do you need to do if you need really quick access to a house? Such as maybe, Tracy, you have a reverse mortgage, you know, or you have squatters, who knows what you have, right? Or you can't meet the mortgage obligations. This will not be a good procedure for you unless you can go to the court and you know, argue for an expedited hearing date under another provision, right? Okay. All righty, so don't worry, there's more. Okay, I think maybe what I did is, yeah, it gets out of the,
There you go,
yeah,
yeah.
there we go. Okay, so just, you know, this is one of our non-bolded, but we're gonna go through these really quickly.
There we go.
So housing by, you know, county by county housing statistics. So these were provided by Andrew DeVries. Thank you very much. And he's not here today, but just wanted to kind of give you guys an overview and remember what median is. Half of the houses are below, half above, right? So this can happen in any county in this state, right? So, and also you'll notice condos and townhomes, those can also be primary residences. And, you know, so that's the regions. You know, there's going to be some of these counties that will be, this will be the way to go, right, for primary residences. Look at Yuba County, right? So if you practice up there or you want to, you know, you'll have to realize that. Okay, and then here's condo and townhomes, right? So, I mean, this could really have a lot of applicability. Remember going back to the legislature, who we started with, their perspective. They're trying to make it easier for families to hold on to a home. Maybe they don't understand court calendaring and hearing dates, you know, and other challenges you might find. Okay. So, but you guys will have these statistics so you can kind of understand. But remember, one of the things you're evaluating when this case comes in is this property, this primary residence, worth more or less than $750,000? Okay, so I don't think you guys have any questions, but yeah.
This is a question, but this always shocks my clients when I have to explain to the probate. There is no deduction for a mortgage.
No.
So that always shocks them that
Right.
my house is worth less than $750 because they deducted the mortgage in the net.
Right.
That's not the case.
No, that is, it's the gross value. Sorry if we didn't say that, but yes,
You're right.
perfect point. Right. Okay.
If it's a TIC, if it's a fractional primary residence, you can still use that.
Can you repeat that?
I think it'll work. Probably that'll be the case that it works the most around here.
Can you repeat for the?
Oh, sorry about that. Yeah, so what the question was, can you use it for fractional interests in a house when you have a tenancy in common and no survivorship? But that would be absolutely. Sometimes you see old title, brother and sister bought a house together and they're both tenants in common. Okay. So, whoops. So this is now going back to the question of, wait a minute, I used to use this procedure for that, you know, hunk of land bought in Shasta County that we were going to build on, right? Now you're going to have to look to other procedures in order to make that happen. So we're just going to not go deep dive on these, but just understand, you know, what you have in your tool belt, right? Okay, so first of all, of course, joint tenancy or any type of co-ownership with a right of survivorship. That works fine. And it's kind of, you know, the homegrown estate planning that a lot of people do, but you always run into the problem of when you have the last man standing rule. Then you got to figure out another procedure to make this happen. Oh, sorry. And then we have, second of all, here, transfer on death deeds. And I don't know if you guys are familiar with these, but you can designate a beneficiary on a deed. And they also take it outright. Title companies really don't like this one. Okay, and we're gonna talk about title concerns in a little bit, but it's an option, right? So if you have that little parcel out somewhere, if the owner did that, you don't care as much, right? All right, so next we can use trusts, and this is usually the gold standard because there's very established routines, forms, but you can also run into issues, of course, whenever we have controversies or if we need a court order, which we're going to talk about. So here is the one little one that we have still available to us. It's the affidavits for succession to real property. It says small value, but I say extremely small value. Right? So this right now, it's I think 51 or 62. It's some tiny amount, right? So we have to look again on that DE 300 to see what the new values will be. But this also requires an inventory and appraisal. So, you know, these things are just not very user friendly. And but this thing, unlike 18, our new procedure here, there's no hearing. This is what you think of with an expedited procedure. You just go into the clerk and they stamp everything for you. And then, of course, we always have our default formal probate. And the big, advantage to this, as we talked about, is the debts and dealing with those. All right. And now getting to our new petition, it narrowly applies to primary residence, right? We've said that so many times. It narrowly applies to 750,000. It narrowly applies that the successors in interest have to be the ones bringing the petition. That's not always appropriate. It can be used for partial interests. And you actually can use it instead of a Hegstead if you are crazy enough, right? Because or, you wanted to try something new, right? So a trustee can be a beneficiary under a will. All right. Okay, so sorry about, what we have available, but this is what we now have to work with. Okay, so any questions on those, on what you have left to administer real property? Yep.
Actually, this is here's a mention of the successor in interest, all have to be present or bring the so there's no like they all have to join in this.
Yeah, so it says the successors and interest. We'll see how the courts interpret this, right? But that's what the statute says, the successor and interest. So then you go to probate code 13,006 to see who that is. And a successor and interest is all of the beneficiaries under the will or all of the intestate heirs, right? So to me, that means they all have to bring it. We'll see if we get some sort of leniency.
I mean, the code is not saying anything like you can have a representative of, all the heirs. It's all the heirs or all the beneficiaries. So imagine if you have a large family, that may not be very workable.
So just to clarify, if you have a formal will and this board, you go to the trustee of the trust, that would be the successor of interest, just that one trustee.
It is. The other people are entitled to notice, but yes, the trustee would be the successor in interest. That's why you could use it instead of a Hegstead. Okay. All right. Yeah.
All right.
So now we're getting into the real fun, people. Okay.
All right. So let's take this through a fact pattern. I may or may not have written this. Okay. Okay. So you as an attorney are presented with the following facts by your staff, who heard the whole story from Becky. So Wilma is a widow with her husband, Harry, having predeceased her after a long battle with cancer. They were longtime residents of Martinez, where they were active in the local bocce league. Wilma and Harry have 2 adult children, Becky and Charlie. When Harry died, everything went to Wilma because all the assets were held jointly, and Wilma was the beneficiary of Harry's retirement. No probate needed. Now, Wilma continued to live on her own until she started developing some signs of dementia. Becky was going through a divorce, and so she moved back in with Wilma. And Becky talked to Charlie, who was living in Southern California, and they both agreed that, you know what, Wilma should not be living on her own anymore. So when Charlie and Becky suggested to Wilma that she move into assisted living, Wilma added Becky to her checking and savings accounts. You don't know anybody like this, right? Wilma's pension, her social security, and her inherited retirement account from Harry were enough to cover her assisted living expenses. So she moved to a very nice assisted living facility in Rockland on June 1st, 2023. So if you don't know, Rockland is in Placer County. Okay, now Becky continued to live at the house. And so while mom is at assisted living, Becky's living in the house. And you know, Becky and Charlie knew that it would be important for Wilma to have an estate plan, including a trust. But Becky heard from a neighbor that her mom didn't need a trust because there was a new law that allowed the house to pass to Becky without a probate. So by this point, Wilma was having a hard time really identifying her children. So they decided, okay, we'll just deal with it later. Well, fast forward, Wilma passes away on April 12th, 2025. Her 3-bedroom, 1-bath home in Martinez was still in her name. There was no mortgage on the house and no other debt, according to Becky. Zillow said the value of the home was $725. So when Becky was looking through Wilma's papers, she discovered the following additional assets, all in Wilma's name. There were stock certificates of 50 shares of Chevron stock worth about $7,200. And there was a life insurance policy without a beneficiary for about $25,000. Okay.
All right, what are these kids gonna do?
Okay.
But it's actually, what are you gonna do? Because this is what your staff is going to ask you. Okay,
Right.
so I am going to ask Esther here what she would do. Okay.
Hunt, no.
Okay.
Okay, all
Okay.
right, so first of all,
Well, I'll ask you this part.
okay.
Okay, so, okay, what about the date of death?
Okay, so Wilma died on April 12th, 2025. So that means that she is within the new 13151 petition procedure.
Uh-huh, okay, great.
Okay. And
Okay, so now what do you think the proper venue for this is?
so kind of interesting, right? Because she owns a home that's in Contra Costa County, but she died in Placer County. But, you know, the home was registered in Wilma's name. She was the homeowner of that real property in Contra Costa. So I believe that the proper county for venue would be Contra Costa.
I agree.
Okay.
Okay, so next, how many homes does she have? Does this fit in with our narrowly now curtailed statute?
Very narrow. She had one home. And even though she had to pay into the assisted living situation, she didn't own an interest in any property there. So one home.
Okay,
So yes.
and then you found a will, or what's going on with that?
So according to Becky, after doing a thorough search through the home and knowing that they did try and, you know, initially do some kind of estate planning with mom, they did not find anything. So she died intestate. So there's no will to lodge.
And what about her debts? Has she been filing tax returns? How does that look?
Well, the only thing that we know is that Wilma, there was no mortgage on the home. As for anything else, we're not sure. But it looks like, you know, Wilma was very organized and regularly paid her bills.
Okay. So you might want to run a credit report, ask them to search the house, that type of thing. So this is part of your due diligence when this comes into your office. Okay, now we're going to evaluate the real property. So first of all, is this thing likely worth less than 750,000? It's in Martinez.
Well, Zillow says 725,000, so that must be accurate. However, this is a situation where it's close enough to that valuation, the limit, that you would want to do some independent verification of the value.
Okay, and then next, what was her interest in the property? You know, we have to make sure that this was her, that she was on title in order to bring this petition.
So we were able to pull the title of the home, and despite Becky's, you know, sort of assumption that she was put on the title, since this was gonna pass to her, it turns out that Wilma's name was the only one on title, and she owned it. She owned 100% of the interest.
Okay, and then finally, the statute requires for us to prove to the court that this is their primary residence. So what would you probably do as a practitioner?
So we were able to pull the property tax records and see that there was a homeowner's exemption on the property, and Wilma was still listed as the property owner for which she was paying taxes on. And her driver's license still had her Martinez address, even though she was no longer driving. Her license was still valid, so it had her home address on her driver's license. So,
okay, so
given those factors, I would say that we could safely say this was her primary residence.
So, you know, trust and verify or distrust and verify. It's up to you guys to verify what you're putting before a court. Okay, so now we're next going to determine who really is the correct person to bring this petition. Okay.
Well, since we were not able to locate a will or any other type of testamentary document, we believe that this is an intestate situation for which Wilma had 2 children, Becky and Charlie, no other children available. So since they are both adults and still living, they would be the intestate heirs.
Okay, and then because they're the intestate heirs under 1306, they're the successors of the decedent. Okay, so we've got the right cast of characters here, if they can all agree.
Right, and so far it seems like Becky and Charlie get along because they live in opposite parts of California. So bringing them together for this petition will be a test.
Yeah.
But for now, it seems like they get along.
Okay, so their story checks out, guys. So
Right.
And they decide to roll the dice with you, go hourly, okay, and enter into a services agreement with you. So, you know, we could talk about, like, you know, when you have a probate, you have statutory fees and a statutory fee. And this is what the calculus the clients will probably be doing. Okay, well, if you probate this house, it's 750,000. Statutory fees are, what is it, about 18,000, right? Or hourly. So they'll probably say, okay, well, let's try it. Okay.
The other thing is, because you're representing them jointly, if you guys remember from the last MCLE program in November that we did about fee agreements and the importance of having them, we need to have a fee agreement with the 2 of them as to a potential conflict. Right now, you know, Becky's been kind of holding it down about how she thinks she's getting the house. And Charlie's not really kind of aware of that. But if we move forward and she starts to assert that, well, no, she really needs to have 100% of that house, we're going to have a problem. So make sure you have that. And if you can imagine, if you're representing more than 2, yeah, could be a problem.
Okay. All right, so now you're also going to check and see if a formal probate has been filed. So based on or whether it needs to be filed. So her other assets are only 32,200 according to our attorney math here. So that means you can use the new small estate affidavit, and you can avoid formal probate by using this new procedure. So you should.
Well, what would happen if those assets were actually more than that? What if it were, we're just going with the 184.5. What if there was a large brokerage account that did not have a beneficiary on there and was in Wilma's name?
So the question would be whether you want to have both of these procedures going. Is this a carve out from the probate? Is there a lot of debts? You know, do you just want to lump it all together? These are all things you're going to have to evaluate and explain to the client. So again, Tracy, to your question about immediate access to the property, your hearing date may be for this 10 months out, right? But you may be able to get a petition for probate even without special administration, you know, fairly soon, within the next 45 days or 30 days. So you have to look at all of these factors to see what really is the concerns of the client.
So I think this situation really illustrates the importance of the interview that you have with your potential clients. Oftentimes, they're just really super focused on the house. And it's your job to make sure that you're understanding what is the entire scope of the assets? What is the entire scope of the debts? And is this procedure really appropriate given that situation? Or is it, you know, as Amanda was saying, you know, what are these other factors that may make it more practical to go with the full probate at that point? So when you're thinking about interviewing, sometimes it's really good to have, you know, a checklist that you are going through with your clients so that they are, you know, digging through mom's, you know, paperwork and whatnot to really provide you with, you know, because worst comes worst, you're going down this route. And then lo and behold, oh, look what I found. I found this annuity that just popped up and, oh, it's worth, you know, $250,000. Oh, okay, now what?
Or you find a probate that's open in Placer County by a caregiver, you know, you never know what you might find.
True. Yes, absolutely, right. You're not just looking for an open probate in the county in which you believe is the proper venue, but absolutely, particularly when they're on their death certificate, they're listed as, you know, dying outside of your county.
All right, but wait, there's more. Okay, so this part that we personally think will be almost impossible for, you know, the public to do, but we're gonna get that probate referee to give us that INA. So if you haven't been on it, this is a website which you'll have in your materials that you can look it up by county. So if you're somebody comes into your office and said, mom had her personal residence in Yuba County, you can go on here and find one. And then, okay, so then what do we get back from that probate referee? Lo and behold, the online it was below it. So yes, so you know, we're firing on all cylinders here. Okay. Now we need to determine who, Esther, do you think would be entitled to notice of this? So you have to look at this probate code section. You're going to get very used to it, 13152A7, and that lists everyone. It's in your materials, who needs notice of the petition. We've really been focused on who is the proper person to bring it, but every situation will be different.
And this idea of the proper notice is not just important for the actual petition itself, but as we will touch on later, it's really important for title. So just keep that in mind. Okay.
So,
so it's Becky and Charlotte.
Yeah, and this one, yeah. So we don't have a really complicated situation.
Right.
So, you know, they're both petitioners, so you don't have to self-serve, right? So that 5-day thing is not going to matter as much. Okay. All right. So now you've done all the initial legwork for this thing, and now you can move forward to filling out the petition. All right. So Importantly, there's no will to attach in this situation, but if you had a will, you know, those things you're supposed to lodge with, the custodian's supposed to lodge within 30 days of death, so it'll be a lodged copy you're attaching. If you had one, and very importantly, for all of our non-detail oriented people, we need to verify the legal description. Make sure that there is no omissions, changes, and my practice is always not just to look at the last vesting deed, which may be suspect. You need to go back to a deed issued by a title company or the initial one to check that, because there can be errors along the way. All right. And so for here, we know she has 100% fee simple. And, you know, you're just completing all these forms in the office. And just to be sure, you have them both signed waivers of notice and say, in case some examiner says, wait a minute, you didn't serve. Okay. All right. So as you guys know, when you sign a inventory and appraisal form, there is a revenue and taxation box 480 that says on there that you fulfilled the requirements by filing the, what I call a DORPO, but it's a death of real property owner in the county. So as the attorney, for your best practice, you're going to be completing this before they come into the office as well. And then that is what informs the county that you have a reassessment event. So you're going to have to also think about parent-child exclusion, filing that homeowner's exemption. So Prop 19 is always going to be applicable in this case, either whether the exemption applies or not. Okay, so, but you guys are all superstars, so you're gonna do all of these to prepare them all before the clients come in.
And because Becky has been living in the house, she is gonna want to qualify for that P19. So that means that she's gonna be filling out or completing and signing the P19 claim form, as well as the homeowner's exemption.
Perfect. Okay, then you're going to review everything for any procedural errors before sending it to our beautiful court, right? Because you want to make sure you're making their life as easy as possible. So this is an old checklist. The Contra Costa County and other counties will develop new ones with the changes. But you know that there's various things, including that INA attached to the petition, which can delay things entirely. Okay, so everything looks good. You have the clients come in and sign. You're doing great, Esther. She's like, is this gonna work? Is it gonna work? We don't know. Okay. All right, then next we're going to file the petition with the court, okay?
And how long do you have to wait before you can file?
40 days.
40 days.
So, but you wait a couple extra days. So you file on May 26th and okay. You got your hearing date on October 31st. All right. And that could be very, aspirational in some counties. Okay, now this looks a little confusing, but you are going to provide notice within 5 business days.
I mean, we don't know how this is all gonna shake out, but I predict that this is gonna be the single thing that gets petitions kicked out and not because of this 5-day notice. I mean, it's just, there's no other notice requirement like this for any kind of petition. And, if you think about these do-it-yourself, how are they gonna get this done? So
and how do they cure it? Because the requirement is 5 days after filing.
Right.
Okay, all right. Okay, so you've done all this, so you're gonna lodge your proposed order and your proof of service with the court. So you guys are all gonna do that, okay? All right, next. So just like any other petition, if the county has it available, you'll check for any examiner's notes. And of course, Esther is perfect as always.
did.
Yes. So, and again, she attends her hearing and she gets effusive praise from the judge. Wow, you must have gone to that symposium. Okay. All right, and then here's some other important things. So you obtain that order, but I would get at least two certified copies, okay? Because remember, this thing has to be recorded, okay? That's why you're there, to get title out of the name of the decedent into the successor of the decedent. Okay, so then you're going to run over to the recorder, record it, or send it in. And here is another thing that we're going to talk about in a little bit more depth in a little bit about why you would want to serve a notice of entry of judgment and or the order on all people. Okay, but she is going to go ahead and do all of that. Right. Okay, so success.
All right.
Okay, so here we're going to, she's gonna.
Okay, let's talk about what ifs. Okay. So what if Wilma had died with her residence and had a Tahoe cabin? Can we use this procedure for both? No, remember, it's personal residence, narrow. Okay. What if there were multiple APNs? So we've got one address, but there are several APNs. This happens all the time.
And it happens all the time with Prop 19, and guess what? You lost your paddle.
You're limited to one APN. Even though it is the same street address, you can only use this for one APN.
So we'll have to see how this is applied in action, right? So we'll.
So without further instructions, I would be looking to see where is the residence, which parcel is it on? Because that's the one I'm going for. Unless we get some further instructions about that.
And for condos, you can have the, you always have that second one where you have a undivided interest in the common areas. That's okay. Okay. So what if you have a reverse mortgage? This is not going to be a good strategy, okay? Because they are very serious about filing those notices of default. And if you need to sell or refinance, this is not going to get you title quickly, okay?
All right, so what if Wilma received Medi-Cal services? Is there going to be some sort of a payback provision for her?
So we believe at this time, Medi-Cal recovery is only limited to formal probate proceedings, but this was one change. So I would keep an eye on this to make sure that these petitions aren't also subject to recovery, okay? I have a feeling that they didn't check in with the Department of Healthcare Services on this one.
And especially because the value of the home that can transfer in this way is pretty high. So I think Medi-Cal is going to catch up.
Yep.
Okay. So what if Becky believes the house should only go to her?
Yeah.
Is this the right procedure for this situation?
No.
No. Because remember, both heirs are going to have to bring the petition together, and they both receive the property at the end of this. So if Becky believes that she has a greater interest, this procedure is not going to work for her. She's going to want to probably challenge in a full probate.
Yeah. And just imagine if you don't really want to be co-owners with your siblings. I have 8 siblings in my family, so that would be yucky. Okay. Okay, so let's see. Okay.
I think we had a question back here.
Yeah, we'll get that. Okay, can you touch?
Unsecured debts that would be assumed by the as the two children, is that all like under that?
So you're asking whether or not the unsecured debts of the decedent are going to follow the property owners, which would be Becky and Charlie.
Which would be the debt from Medicare.
Well, so Medi-Cal is a specialty creditor, right? So there's very specific rights that they have, and any of these super creditors like California Franchise Tax Board, IRS, Department of Healthcare Services, those child support liens, those type of things. Be very careful whenever you have them. Right now, the only recovery for Medi-Cal is through formal probate when you have this type of situation, or if you had a first party special needs trust. But the other unsecured creditors, let's say ambulance bill, credit cards, right? They are able to then go after the people who receive the property up to the value of the property. So it's really important to evaluate those debts before you move forward with this.
Yeah, so Wilma had a real shopping problem. Yeah, the kids are not be on the hook.
Let's change up the hypothetical a little bit. Let's say Charlie is a predeceased son who left two surviving teenage children.
Yes.
Would this still be a good petition to use in that situation? Or are you going to end up filing the guardianship of the estate? And
So you'd probably need a guardian ad litem or guardians. You would probably need guardians because they would then be in recipient of those of the house. And so that would be not a good use of this procedure.
to change the hypothetical again, Charlie has no children. Charlie really appreciates what Becky did to their mom. He disclaims his interest. Could you just attach that to the petition and have Becky be the sole petitioner?
I think you could probably try, but when, so that's if you could disclaim, right? But would you be disclaiming in favor of your sister or your kids or?
He has no kids.
He has no kids, then yeah, I don't know, you could try it.
Let us know what happened.
Yeah, let us know, yeah, until, you know. Okay, one more question and we'll move on.
13-151 petition is in place for the first 2025, but if somebody passes away prior to that, they still use that old procedure.
Okay, so that was the
Terms of what happened, it's been like that long, died in 2021, and
So that is an interesting question. So that is, if you have somebody, say the client's come into your office, but mom died in 2021. So what it looks like with the proposed forms is these statutes changed effective April 1st, 2025. So you have to look at the date of death to see what the small estate exemption is for that person. So if it was 2021, that was before it went up to 184. So you'd be in the 166 to 250 range. So you'd have to fit within that to use that. So most likely you're looking at probate in that situation. All right. Okay, one more.
I'm fascinated by the part that you can choose whether to do this process or the formal probate. If you elect to do the formal probate, is there any notice disclosure requirement to your client? You know, if you chose to espouse a property petition or a formal probate of a spousal property, you have to tell them like, you are going the more expensive route kind of thing?
We have seen no
Okay.
disclosure like that, but they're entitled to notice. So it's up to them to know.
No, I could see,
Yeah.
you could see the clients getting mad.
Mhm.
You're charging me to do a full probate. and
Yeah.
like, so I would say, oh, I'm gonna do a full probate because these rules are ridiculous and, you know, like this is.
Yeah. Yeah.
But then the client coming back to being like, wait, if you had done this and only charged me hourly, it would have only cost maybe $3,000 and now you're charging me $18,000.
Yeah. So the question was, if you just decide to go with a formal probate, is there any disclosure? Like when you had to do a spousal election to elect the spousal share into a probate, we've seen nothing like that. But, you know, there's always time for more little tweaks. So, yeah, so this is all brand new. So we'll see how it works out. Okay, so we wanted to go through now a couple of other perspectives for this, okay? So we've been looking at it first from a legislature, practitioner, clients, but now you're also estate planners. And gosh darn it, would you ever use this as part of your estate planning process? So I think there are some real risks if you are relying on this as an estate planning tool. Okay, I think it's more a safety hatch in case, oops, look what happened, versus something you would actually plan for. So again, Tracy, your thought about needing that immediate access to the house, and especially when you have a mortgage, it's, you know, it's hard for the family to absorb those costs. You may have a complex family structure, right? Blended family. You may have somebody who should be an heir, but isn't an heir because they weren't adopted, or, you know, all these kind of crazy things that happen. And also you may have a situation where people cannot own their interests outright. Right? Are they on public benefits? Are they a minor? Are they conserved? Are they a spendthrift? So, you know, there's a lot more that goes into estate planning than avoiding formal probate. So these are some of the considerations. And also, right, mostly people come to you for a private arrangement to avoid court. This does not avoid court. And it doesn't simplify things either, right? So, and then,
I mean, just
Yeah.
to add on to that, if you're thinking about when clients come to you and they want a plan.
Yeah.
That's very different than the person's already deceased and they have nothing, or they have something very simple that is not adequate. Then we can look at this tool and see whether or not it would fit. But you're generally not going to want to be saying to your client, you don't need to do anything because we got this great 750, you know, this petition through this new law that I think will just do you, you know, no. So, you know, that's why the title of our program is Are Trusts Dead After April? No, they are definitely not. Definitely not.
So, yeah, so this is your role as an educator to the public,
Yes.
right? You know, you need to get ahead of this and have talking points when people are coming into your
Yes.
office, or information that's accurate on your website, you know, about why
We definitely
things.
need like a little zinger that we could tell to Becky's neighbor. who's
Yeah.
Like, yeah, you don't need that. You're fine. Well, no, not quite. So,
Yeah.
So this is going to help you to do that.
Yeah, and then also, right, usually they're coming to you because they want to avoid court, they want privacy, they don't want their business, they don't want to be waiting months in agony, right? This is usually not the gift you want to give your family. Yeah, so, and we will be talking very shortly about title companies. We talked a little bit about reverse mortgages. And you don't want to have fights about who are the successors of the decedent, because frequently clients have a different view than the law, right? All right, and then a few more things. Okay, and then the problem with that, this narrowly applies to your primary residence. What if you change primary residence, or you rent a condo and you decide to rent the house, right? This is not a stable planning opportunity. Your house may appreciate beyond the value that they set by the statute. You know, they may expect to own more than one real property. So you guys see, like, maybe it could work in a very narrow set of circumstances, but it's more kind of like the, you know, homegrown informal estate planning approach versus what a professional would probably recommend. Okay, so any questions about how to talk through an estate planning meeting where clients are going, you know what, I'm okay, I'm gonna rely on that. Okay, everybody's good. Okay. Now here's, okay, you guys thought you had enough. How much time do we have? Okay. Okay, we'll
hit the highlights. of
we'll
this,
hit the highlights
and
of
then
this.
questions.
Yeah. So, and if you have to leave, run. Okay. Okay, so title companies, right? So at the end of the day, what are we trying to do? We are trying to get marketable title to the successors, right? They don't want a parcel of property that they can't sell, get a loan on, you know, transfer to their own trust, right? They want to have something of value, and that's what is valuable in real estate. So title companies, believe it or not, are reluctant to issue title whenever they see an order in probate, and especially for impropers. But they are on the hook. And with what I understand from the title companies, with this wave of baby boomers, right, they're looking at a huge problem with even staying solvent. So what do and of course, our younger generations are relying on their inheritances due to economic conditions. So you guys have all this. So let's think about then, so they have uncapped liability. So you're thinking about the fire company, you know, all of these insurance companies are really behind the 8 ball. So what do title companies really care about? They want to make sure that that order is bulletproof, right? So because whenever you have a probate order that is transferring property, you haven't had title insurance issued in that transaction. So no one has looked at it. So we have, title is like this, it's a chain. So they see that as a chink in the chain for title. So what are they looking at? So their analysis really depends on who are entitled to notice. So in this situation, you're going to want to make sure that anybody that you think may be entitled to notice, get notice, okay? And you are going to want to save those proofs of service, okay? I know. So during the time that there's that issue of when it can be appealed that we talked about a little bit earlier, just briefly. So normally it's 180 days. But if you serve a notice of entry of judgment or the order and proof of service, you can shorten that time to 60 days. So just imagine you've waited for a hearing date for 5 months, and then title company says, oops, we're not going to issue title for another title insurance for another 6 months. So as a practitioner, you can shorten that to 60 days. And if you don't, or if they find an issue, the title company, this is in addition to the court looking at it, they may require people to sign off on the transaction or give up their interest or waive their right to judgment. So this is going to come up more and more as we're seeing people, especially baby boomers, leaving us, and we have improper notice. So really important when they see an improper and a probate order, because they don't trust that maybe they have everybody notified, but they're more and more looking at attorneys too. And we don't want this as our retirement gift. Okay, so we have some more information in here for you guys, but we're really running out of time today. But we have information here about risks in any type of administration with title companies and how to mitigate that risk for your clients so they have clearer title. And so what the key takeaways really are is when you're closing this file, make sure you give the clients a certified order in addition to one that might have been recorded in case something happens, that they have all the proofs of services, they have any underlying documents that show who was the successor of the decedent, because they may be asked for these things in title. So, you know, it's the gift that keeps on giving, this area of law. Okay, so any questions briefly on the title insurance considerations of what you guys can do? Yeah, you're all like, we need to get to work. We need a drink after this. Yeah. Okay, so we can wrap there. Yes. And like I said, you guys will have this presentation. It has all the links in it, so you guys will be able to get to the new forms. Has all the statutes, so you have, this is your new reference book.
Thank you.
Yes.
Curiosity, is there anybody from TexCom in here? Was there anybody from TexCom that was consulted on this?
we had a full discussion today, I think it is feedback on it, but it didn't come from Texcom, so, they just had input.
Thank you. Please feel free to enjoy some beer or wine and think about this statute while you do so. Have some food. You won't be allowed to leave until the food is gone. So thank you all for coming today. I hopefully Amanda will stick around, and if you have any questions, you can
No, feel free.
So thank you again. We really appreciate it.
Oh, you are so good. This is a fun section.